with Fanny, playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey, folks! Wow, okay. Jury instructions have just been told. Now they're still debating on how and what they're going to send back. They are still talking. I'm not used to this. I'm used to, hey, yes, a laptop with all the evidence. You cannot go on the internet with it. Off you go, and come back when you have a verdict. But hello, Mr. Jingles. Hey, Mr. Jingles is here. Mr. Jingles is here. Yeah, and I listened to bits and pieces of the jury instruction, and I must say, the jury instructions are way worse. Ow, for fuck's sake. Boop me without claws, Mr. Jingles. Boop me without claws. I just started, Dave. The jury instructions are way more damaging for the defendants than anything the state put up against them in evidence and witnesses. But we will get there. We are technically on verdict watch. Don't use the claws. Poop without them. No? Oh, you're pretending. Yeah. So we are okay. Excuse me, Mr. Jingles needs some snuggles. Hello. Well, they recall them. All right. Why? What's going on? I was planning for a quiet recap while waiting. That's not going to happen. All right, let's go. Well, yeah, they are still fighting over the instructions. All right. All right, let's go to that. I thought I would do a recap and have lots and lots of fun at Hilton's rebuttal thingy. But yeah. But it seems like we are. Yeah, let's just go. Where did they? to the point half an hour ago or something like that when the jury instructions stopped them. All right. Change of plans, I guess. Dun, dun, dun. Posting sound.
Okay.
Page 2, Your Honor.
On page 2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang
make
on a second. Let me get there. Page. Where are you talking about?
So count 50, where it's participation in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you last paragraph, any out of court statement.
Hang on. Yes.
As we were reading it, the thought came that maybe we should add any out of court statement made to law enforcement, made to the police.
Why?
Made by one of the defendants on trial in this case after the alleged criminal act.
No.
We probably should have.
Jesus Christ, Miss Hilton. You have had years for this. And now, after she read them, you want, Your Honor, can we add this? Oh, God, no. They can't even behave after more or less the trial has been handed to the jury. They still want more people in, more evidence in, or more
I
instructions.
gave y'all this, I don't know
They
how many
are
different times to
never
look
happy.
at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
Can we add it, and then when you send it back?
Generally, hi Kathy Hudden, hi Nick, you are not here yet, but I thought demonstratives was not evidence. Generally, demonstratives are only there to make it easier to explain for an expert witness or something. That should not be evidence because it's just a demonstrative. Now, if they use an actual piece of evidence that is admitted as evidence and they use it as a demonstrative, yeah, then it can go back to the jurors. But just a demonstrative, for instance, Doug Weinstein's short of reasonable doubt, that can't go back. That can't go back to the jury because that is just a demonstrative.
Sure.
That's all.
Or-
Your Honor. I'm just going.
You never know
Made
with
by one of the
Georgia.
defendants.
Weird stuff that
Made
happens.
to law enforcement by one of the defendants on trial.
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know Your Honor stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay,
Within the jury charges, and I understand that, but I'm just going to renew my objection.
okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper,
Okay,
and we're just going to attach the flash drive to the piece of paper.
okay. And those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting.
We don't normally send the actual media out with them.
Okay,
I mean, they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, you know, I'd like to watch the FedEx tape again.
Okay, my understanding, I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, and I believe the Defense Counsel has an objection, we were going to send a legend out with the letters and what letter is associated with what act, so that they would know.
What
We
letters?
organized
I
them.
don't know what you mean by that.
So every act that we presented, so for example, VV was the Chamel Drinks homicide, so that they can know when they pick up a letter, what that was in reference to.
Hmm.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence. And quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct over acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask.
Yeah, generally, throughout the trials I've been covering over the years, they have all the evidence already. Narrating it or trying to help them find evidence by either the prosecution or the defense. No, I'm not happy with it. I'm absolutely not happy with it. Even if it say, oh, we're just going to index it. No, because this prosecution will try to index only the good stuff for them, which is about 3 things. And all of those are jury instructions.
To re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about 2 issues: the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay.
Mr. Sharp.
All right. Does the state feel?
All right. I set a goal. Apparently, my YouTube handler says, do that. It will increase the interactions and so forth. So I set a goal. You can see it in the chat. It is 15 super chats for $5 or more, or $4.99 or more, within 2 hours. And what I will do is read you a story from this book. Swedish folk and fairy tales. Because we are technically on verdict watch, and we might be here for some time. So 15 for $4.99 or more, and you will get story time with Nick. All right, let's get back to this.
Well, that the CAD reports or the demonstrative should go out.
Yes, Your Honor, we have case law regarding demonstrative evidence
Okay.
that demonstrative evidence does go back to the jury, and it's a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
This state will cite Ruffin v. States, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm. Okay. And then how about the CAD reports? What's the objection to the CAD reports? Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are
Thank you, Lynn Britton.
looking. I thought we had the case.
Who gets
at one
us
point. We are
started
looking
for story time. Thank you so much. That is so sweet of you. Thank you. And thank you to Erin. Is Mr. Jingles ready for this crazy round? Meow. I don't know. Oh. He is currently licking his claws. Okay. Yeah, I would say he's ready. And thank you to Snivels. Thank you so much. With popcorn. And thank you to Jessica, who said thank you for your dedication to covering this trial. I can't imagine it's been easy. Oh, at times, folks, it's been excruciatingly boring, especially while Judge Glanville was still on it. We had a full month of just technical evidence, cell tower data, phone records, text messages. And I was here for it. Kathy Hutton, just because Nick is so cool and fun to watch. Thank you so much. We're almost halfway. Let's see here. 1, 2, 3, 4, 5. Yeah. No, we are a third of the way already. Thank you so much, guys. Thank you so much. Okay, they are working.
Yes.
Okay.
I have a case, Your Honor. It's a March 2021 case. I'm going to spell it PATTAROZZI with state.
Hello, Deja Vu.
75. It stands for basically what the continuing witness rule applies to, and CAD report would not be something that is listed as something that would go back because it would be a continuing witness because it's an original evidentiary document and it's non-testimonial in nature.
Thank you, Erin. Nick is by far the kindest
Is it-
YouTuber. Let's get him to the 15 quick. Meow.
Cover CAD reports.
Thank
all,
you
or is
so
it just
much.
Kind of here's what continuing witness means.
It's here's what continuing witness means. I couldn't find a case specific or on point as it relates to.
It's hard to believe, honestly.
Yeah.
If we the conclusion, they go back.
Yeah.
So that he couldn't find case law on something he wanted in, but go figure.
So does the defense have any?
And thank you,
Case law
Steve
on
Keith,
CAD
for
reports?
gifting 5 memberships. Thank you.
So I'm looking at a case, Muse from the Supreme Court from last year, 316 Georgia, 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos. And it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted.
A CAD report is it's like a closed captions. It's what they can hear or translate into writing. It's not necessarily correct. That is why always the actual recordings, in my opinion. And thank you, Steve, for gifting 5 memberships. I will count it in, but the actual goal set didn't count it in, but I will. And thank you to Erin gifted 5. Thank you. Now I have to make some calculations here. Erin, 5, 10 plus 5.
What does CAD stand for? Computer.
That's $25.
Computer
Thank you so
aided.
much, Erin. All right. Honorary Viking. And that makes Erin Passaretti honorary Viking of today with a combined $25. Thank you so much. That is so nice of you. Thank you so much. I will also count that into the goal, even though it doesn't show up there.
Mm-hmm.
I want to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls,
Mm-hmm.
in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding of the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. That was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA.
Yeah.
But I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case, it's pretty new. Davis v. State, 371, Georgia Appeals 469, 2024 case.
Thank you, Liam Britton. Getting us closer to the goal.
I mean, in the Paparazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence. And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
And Erin keeps going. Thank you so much. Thank you so much. bringing Erin's contribution today to 30. And she extends her lead in Honorary Viking of today. And then Deja V gifted 5 memberships. Wow, you guys are on fire! How many are that? About 5, 10. 15 gifted memberships. I will add that to the banner as well. New members today. 15. Actually, it's 16. I saw. Dun, dun, dun. Save. I actually saw True Crime Lover 77 became a member in the early seconds of the stream. Thank you so much. So that is 16 new members today. You guys are so amazing. No, Brandon Blackfire, you did not come just into. Well, if somebody else, if more people do it, then maybe Brandon Blackfire. A few months ago, when I would stop in, there were only around 20 live viewers, and now we are over 100, plus all the support, member, and super chats I see popping up. Yeah, I mean, I'm amazed. I mean, go back to streams I had in February and March. I sat for 9 hours, and I had a combined 300 views. And thank you to Deja V for gifting 5 more memberships. Thank you so much. Thank you to Snivels for 10 gifted memberships. Thank you so much. And thank you to Steve Keat for New Zealand $5. Thank you for being awesome and having a great channel. Thank you so much. That brings us to 9 out of 15 supers. But with the gifted memberships, I think we are at the goal combined. But just in case, you have an hour and a half. An hour and 47 minutes to get there. But I want to listen to this part before I bring out the storybook.
It is true. It is what Mr. Atkins said, to my recollection, is completely accurate. As we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections.
Right.
And some were redacted.
Yeah. All right. So then I think it would be my conclusion that it is all right for them to go out as long as they are all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right. Did y'all, I hadn't had a chance to look at the demonstrative law yet. Yes.
Here comes Erin again with another $5. Jump up and down on the heart emoji. Help boost the algo and let people know Nick and Mr. Jingles are live. Thank you so much. And you extend your lead even more, getting us to 35 for Honorary Viking of the Day. Thank you so much. Did I update the... No, of course I didn't already. 10, 15. We had 26 gifted memberships. 26 new members. What you're hearing now is from the court. I can't do anything about it. The thingy. Kathy Hutton doesn't have the option to gift memberships. If you're using an iPhone, you have to go out from the app and use a web browser. Then I believe the option will pop up. But I'm not sure about that.
All right. My reading of reference is that demonstratives can go out with the jury.
What? What? They are sending out demonstratives with the jury? Demonstratives aren't evidence. They are just a tool for either the opening or closing or an expert testimony. They are not evidence. They are only supposed to reach a verdict with the evidence presented, not the damn demonstratives. Are you fucking kidding me? Are you freaking kidding me? All right, demonstratives. For instance, if you remember Doug Weinstein's, he had a big board with here are the levels of beyond a reasonable doubt. That's a demonstrative for him to visualize what he is talking about. Some of the expert witnesses, for instance, you saw Atkins using that triangle of evidence and his PowerPoint. Those are demonstratives. They are not evidence. They are the narrative either of the parties used to make a point or make something clearer according to them. But they are not evidence. But in Georgia, it's allowed. How the fuck can it be allowed? Brandon Blackfire. I've learned a ton about law from watching you. Oh, thank you. Thank you. I actually want to be a lawyer and go to law school, but I feel like I may be a little too old for it since I'm turning 30 in December. If you can afford it, and if you want to spend 6 years in school or something of the sort, then you have a good 30 years of practice in front of you. So age, now if you're my age, then maybe if you are between 50 and 60, you might want to reconsider such an option. But if you're barely 30 and you really want it, Dave says it's 3 years and 30 is not too old. Yeah, Dave, come on. Tell the people when you went to law school. Dave. Let's see. Do I still have it? Do I still have it here somewhere? I'm putting up the Dave signal. Oh, you have a family. All right, while we wait for that, here's Ghost. Thank you. YouTube's directions. Apple, join, and gift buttons are currently missing on iOS inside the YouTube app. Open the channel page in Safari browser to purchase gifts or to join. Oh.
Well,
Hey, Dave, is 30 too old to go to law school?
no. And in fact, it's probably better for the practice. One of the things that a lot of kids right out of school, they do like pre-law or government or whatever, and then they go into law school and they realize they don't like it. But the other problem is that unlike, say, medical school, it's good to have a different background for lawyers. So I was a contractor and I had a furniture store for many years before I went to law school. And I graduated when I was 30. I just turned 30. No, 31. I started practicing when I passed the bar. And but there were people that were older than me. There were people from all walks of life, and that's what makes the practice good. So when I got out, I started doing construction law and litigation right away because that was my whole background. That's good as opposed to someone who's fresh out of college, never had any experience working in the trade, and then hire them to do, contract litigation or something like that. It's you don't have any of that experience. So 30 is not that old, but it is a big commitment, expense and otherwise. I say law school is as hard as I thought college was going to be when I was in high school. Meaning when I got to college, I was like, oh, this is fairly easy. It's just like a little bit more work. And law school was a lot of reading, a lot of work. I went on vacation with the family and kids and I took my stuff with me. So it's a big commitment financially and otherwise, but you're never too old.
Yeah. I mean, I am, for instance, I have a degree in food tech, but the union picked me up before I even graduated, and then they paid for my law degree. But that law degree took me 7 years because I was working and I went to school. So it took me 7 years.
Yeah, and I found the reason I went to Thomas M. Cooley Law School, which a lot of people knock because it's lower in the rankings. But let me explain. They take just about anyone. You have to take what's called an LSAT to get admitted into college. And some schools, like U of M, I'll use for example, have a really high requirement for the LSAT. But once you're in, you're essentially graduate. There's no way you're not graduating law school once you're in. Cooley did something different. They said, we'll take people with lower LSATs, but you can get washed out fairly quickly. And a lot of people did. I graduated with about 20% of the people that started with me. A lot of them washed out. The other thing with Cooley, which was nice, is that they had weekend-only classes. So I would schedule my classes on Saturdays and Sundays. I'd be there for 8 hours both days, and then it allowed me to work Monday through Friday. So, so there's programs out there that are available.
Erin asked, what are your thoughts on the need for legal nurse consultants? Now, I don't do civil, but I would assume that it can come in handy depending on the specialty of.
I mean, a legal education can go a long way. In fact, when I started my law school, you have to have a bachelor's degree to begin with. So I already had that. And then they had a program going on with Oakland University where you could get a joint MBA and law degree, which is really nice because a law degree will help you in any industry that you're in. Much like an MBA kind of helps you with any business management. It doesn't matter what industry you're in. So they had this joint MBA law degree program. Because if it's like speaking Mandarin, if you want to get a job and you're like, oh yeah, and I also speak a second language, you're moved to the top of the stack. So if, oh yeah, I also have a law degree, you're kind of moved to the top of the stack.
Mm.
So that would be my opinion would be in any industry that could be beneficial, but you might not reap the financial reward, right? It might not. Law school is expensive.
Mm. Yeah, I mean, I can't say after 30 years contracted to a union, my area of law might not be beneficial in another career. I've been told so by numerous occasions. You will never work in this. Oh no. Oh
Well, I
no.
actually so the job that I was working at the time I started law school, I was let go. My boss had he had a fragile ego to begin with, and I was a little more competent than he was, but I didn't care. I didn't want his job. But then once I said I was going into law school, I think they thought that I was going to be practicing law against them. They thought that I was going to be a problem child, which I probably would have been. And so they let me go.
Oh, Erin has her bachelor's. You just need a certification. Go get
Nice.
it, girl. Go get it. Go get it. Way to go.
Yep.
right.
Also, I will say that I don't know if they're still doing it, but Steve Gosney and Andrew Branca were doing have a online sort of law school program. It is just like law school, from what I've been told, meaning you study the same cases. It's the Socratic method. You really, the reading requirements are very similar. But it's not accredited, so you don't get the law degree, but it's a hell of a lot cheaper. So if you're interested, or if you want to know whether or not you would like law school, go try that program. I don't have a link of it, anything. I'm sure Steve and Andrew Branca can get you guys a link, but I would say go check it out there. A lot less expensive, and you can see if you like it.
Yeah, let's see if I can find it.
Yeah, I don't know if it's still going on. I know it was, and I don't know if it's constant or if they just do it for a window and then stop and then start again.
Okay, let's see here. Well, he has his Learn to be Hard to Convict and the Best Legal Defense. I found that. But that's not what I was actually looking for.
No, let me see if I can find a message that Steve had sent me a while ago about it.
Well, they are invited to this Verdict Watch stream. So if they show up, because Steve Gosney teaches on that law school, and so I do believe he has the equivalent of more or less a professor of law.
Okay.
Does MLS?
So they do 14 classes. Each class is 90 to 120 minutes. There's one final exam. It's just like law school. Let's see here. What's it called? Never actually sent me the name. Oh, he emailed it to me. Oh, crap. Now I got to go through my emails. Let's see. That would have been back in, February. I got to go back through my emails from February. Jeez. All right. Let's see. Within, we'll say 1 week of, we'll pick a day in February. We'll find this out. We are here to serve you all. Let's see. Actually, what day did he send that? February 22nd. So let me go February 22nd. Search. Wow, there's a lot of emails I did not open.
Lawofselfdefense.com has an enroll link, but that is to his course in how to be difficult to convict in self-defense cases.
Yeah, they have. It's something different. It's Did I give him a different email address? Oh, this is going to be disastrous. Let's see here. What email did he send it to?
I don't know. Well, let's try asking him.
Oh, no, it was something else. I don't think he. No, he didn't send me an email about it. That was something else. Oh.
Well, I sent. I asked. I sent via DM.
Yeah. So, but no, 30 is definitely not too late if you want to become a lawyer. Just you do have at least 30 years of practice in you.
Yeah, I mean, most attorneys I know never stop practicing law. They rarely
I don't
retire.
think I ever would. It's American law courses. That sounds right, Brandon.
Yeah, that sounds.
It's a good way to.
Oh, here it is. Here it is.
It's a good. Yeah, that's it. Yep.
Yeah.
You can put it in chat. That is a. It's a good way to inexpensively decide whether or not you like law school, whether it interests you. Oh, I posted it under your name. Oh, you did too. Yeah. Okay.
Yeah.
We doubled up. So that's a good sort of like dip your toe in the water without too much commitment. See if you like it. It's very intense. In fact, I did a review years ago about My Cousin Vinny and how realistic it was. And then I did a review, and I might do it again on my new channel, of Legally Blonde. Now, if you take the time frame that the movie takes place, and they show it within the first year, but if you stretch it out to 3 years of law school, and I'm talking about like the externship that she does where she's actually working in court and stuff, that's usually your third year. It's fairly accurate, especially the first scene when she walks in and the professor expects you to have read everything ahead of time. And if you can't answer questions, then you're kicked out of class, and it's very Socratic. It's very realistic from a law school standpoint. Now, granted, it's a comedy, so some things are, made comical a little bit, but I find comedies regarding the legal profession more accurate than the dramas.
Oh, definitely.
Yeah,
definitely. I mean,
check it out.
I'm having a whole. I mean, it's entertaining for me to watch like the CSI shows, knowing that that's not how it works.
It's so frustrating for me to watch those shows. I sit there like, that's wrong. That's wrong. Objection, leading, speculative. Why is there no objection? I hate why those shows. Or even, what did my wife turn on the other day? Oh, Dateline. She turned on Dateline, and we were listening to, dramatic and all this stuff. I'm like, I can't handle this stuff.
Yeah. Some of the things, especially since I more actively started watching American trials, real trials.
Yeah.
The Law and Order stuff. No. That's not how it works. You don't get gotcha moments. You really don't.
I got one gotcha. I got one Perry Mason or Matlock moment. And it was in a divorce case. And this woman was trying to claim that her homeschooled child was up on all of her academics. And she wasn't behind at all. Now, this child was 9, so should have been in like the 4th grade or something. And so I said, okay, well, what are you working on? Oh, we're working on this and that. Well, how do you know she's up to date? Oh, we keep track of it on this. And I said, okay, show us the report. She's on the stand. This is in trial. This is not a deposition. And I say, can you show us the logs? And she says, no, they're on the computer. They're electronic. And I said, I hand her my laptop. I'm like, here it is. Log in. And she, oh, I forgot my password. And I said, well, reset your password. Oh, well, I don't have my phone. Well, who has your phone? My attorney does. Well, here, let me hand you your phone. All this to try to avoid it. And she logged in. I had no idea what it was going to say. And sure enough, it showed that she was working on kindergarten work.
Oh.
Less than 1st grade. This is like stuff that 6-year-olds do. And so that was like my Perry Mason or Matlock moment. I was like, see, she's not being educated. She also used like fairy dust for toothpaste and slept in the same bed. It was all kinds of wrong, but
Oh.
that was my Matlock moment.
Yeah, but usually
TMI.
and it's just like with the CSI effect. Oh, DNA, we checked that hair, and it's within that afternoon the results come back. No, first you have to bring it to the investigator's attention. Then you have to actually apply to have it tested. Then you have to submit it to the lab with specific instructions, and then you're put on hold until they get to it.
Yeah. I mean, it's just not. What is the other one? Was it Law and Order? Law and Order, where like they find a dead body and the next scene they're in court, and it's like no. No, there's a few steps. They're always in court, and they always have like that 10-minute hearing, and then they move on, and then they're back to the investigation. We're like, no, that's not this. None of this is in the right order. None of the timeline works.
Where are the numerous extensions?
Yeah.
Where are the my lawyer isn't here, Your Honor? Where are the where are the prosecution forgot his files? Where
As I say, my cousin Vinny is extremely accurate when it comes to criminal procedure. It's the only movie or TV show that I know of where they actually hold a preliminary examination. Nobody even knows what a preliminary examination is, but they conduct one, a full preliminary exam. It's amazing. And it's funny and it's entertaining and people love it. Be accurate, people. Don't do all this drama BS.
I mean, how LawTube has exploded since Rittenhouse. Before Rittenhouse, there were a handful, maybe. I mean, back before Rittenhouse, I think EDB had maybe 100,000 subscribers and was a giant. Now, there's quite a few 100K LawTubers out there and more. And now she's closing in on 1 million subscribers.
That's good.
Yeah.
I have a plan. I have a plan to get Emily D. Baker on a Lego stream one day.
Yeah. Good luck.
We'll see how that goes.
Yeah. She is busy all the time. So, folks, if you wouldn't mind, if you haven't subscribed yet, make me the Santa Laws of EDB. Also, just subscribe, folks. It's free. You're here. You already like me or hate me, but can't get enough of me. So
I heard. So I was listening to you in the background a little bit. That's why I piped up with the 30-year-old thing.
Yeah. Did you hear about they were allowed to bring demonstratives back to the jury?
Yeah. So that's interesting. I don't know if that's a Georgia thing or not. Like in Michigan, we can't. The jury doesn't get demonstratives.
Yeah.
And I don't know of very many states that do. But again, each state has their own rules. To have demonstratives back in the room, I mean, if they have both of them, there was a case, I don't know if you were covering it last year or not, or somebody was, where the defense attorney wrote had a big whiteboard the whole time, and he would write timelines and he would write witnesses' names, and as they were testifying, he'd write down the timeline, and it was very cool because it kept everything in a chronological order. That would be great to have back in the jury from a defensive end, but then like these demonstratives, the slideshow with like the demons and stuff or whatever they had going on there, that would be horrible to allow. So it's a kind of a double-edged sword if you're going to allow it. It's not a Georgia thing, maybe a Fulton County thing. That's interesting.
Yeah, I was on it because the jury is supposed to find it through evidence and testimony. Now, an expert might use a demonstrative to make his speak or her easier to visualize. But bringing it back,
It's not
Especially-
evidence. See, that's the thing. Like the judge should in the jury instructions say that the attorney's comments are not evidence,
yeah,
right? Their opening statements, their closing arguments, any other their objections, their questions even are not evidence. Only the statements from the witnesses and the admitted evidence is evidence that the jury can consider. Well, what is demonstrative? It is the attorney's words. It's statements by the attorneys because they're the ones that put that together.
Mm.
So if they can't consider it, if they're not supposed to consider it, why is it going back there into the jury room?
Yeah, but I don't know if the demonstratives in this case is demonstratives the expert witnesses had with them. For instance, I don't know, the cell towers things, but
so those, if it's demonstrative that the experts put together as part of an opinion, that's different. I remember I had we had a car accident, like one of the only car accident cases that I had. And of course it went to trial, but I had a like clip art image of a spine and I had the doctor shade in the parts of the spinal cord and everything that were injured. And that was technically demonstrative, but because it was part of my expert's opinion, that could go back.
okay.
So that's different. That's not something that I put together just to outline a case or to tell a story. It was something that the expert actually incorporated into his opinion.
Yeah. Let's go back and listen to what was actually said here.
All right. My reading of reference is that demonstratives can go out with the jury. Y'all, if y'all got something contrary to that.
We'll just be clear what demonstratives we're talking about. They all-
Mhm.
I believe there's some physical evidence that Ms. Weaver may have in her,
She's got guns and drugs.
for the drugs.
Neither of those is going out to the jury. If you have pictures of them, those can go out.
That would make jury duty a much more entertaining. Where's the evidence? I don't know.
So what was that case that she cited? I know she gave the shortened citation. Do we have the whole thing?
All right. My reading of reference is that
Ruffins?
demonstratives can go
Ruffins?
out with the jury.
Let's see.
The continuing witness rule is inapplicable where the documented issue is original documentary evidence or.
And that was,
Let's see here.
I'm gonna share this in case
Mhm.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls,
Mhm.
in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person.
Yeah, that's not about the demonstratives. They're talking about CAD reports. So she must be referencing something that they talked about earlier.
Non-testimonial evidence would be demonstrative, though, is it not?
Let's
Mhm.
I I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls,
Mhm.
in our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redact it. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. But, and that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA. But that, I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case, it's pretty new, Davis v. State, 371, Georgia Appeals 469, 2024 case.
What did he say there? Let's slow it down and hit the enhancer.
On that part. That was all I wanted to share, Your Honor.
There's another case, it's pretty new, Davis v. State, 371, Georgia Appeals 469.
Okay, so I have a Georgia court rule here.
Okay.
It says that demonstrative evidence must be relevant, and its probative value must substantially outweigh the danger to unfair prejudice, confusion of the issue, or misleading the jury. But it can be admitted if it doesn't mislead the jury. It's not unfairly prejudicial. It doesn't confuse the issue. And it's relevant. It can be admitted. So that's under Georgia court rules.
Okay.
That's 24-4-403 if anyone wants to look that up. So there you go.
So it is basically the judge's discretion.
Yep, pretty much. Now, the case that they're citing probably sets out some sort of tests to determine, to guide the judge in her discretion. But it sounds like if it passed those tests, then it's admissible.
Okay.
So there you go.
Yeah.
So, and I understand too. I was going to say, is it my understanding that a laptop with all the evidence is going back with the jury?
That is my understanding.
That's probably better than the jury saying, "Can we see this?"
Yeah. Well, the films and the physical evidence, the calls, they have to. Everything is referenced, but the actual the drinks murder video. No, they have to actually go and say, we want to watch that again.
Okay. Interesting. All right. I'm trying to think of the last case that I took to a jury trial and what was going back with them. Everything was going back with them. Yeah. Most of it, there wasn't a lot of documents, though. There were some photographs. But, yeah, most of the stuff was going back with them. And then the videos we would play in court. That was Oakland County. So if they wanted to watch a video, we would play it in court because no one wanted to send a laptop back with them. They're like, yeah, you want it? Just come on out. We'll play it for you again. So that's what we did. That was the reason why, though, is no one wanted to send a laptop back with the jury. No one wanted to wipe out their entire laptop and send it back. So we were like, nah, we'll hang on to it. But anything that was tangible, physical documents and stuff, we sent back with them.
I think
might be the same reason.
Yeah, throughout the trials I've been watching, all the moving media, so to speak, those they have to ask for, but all the transcripts and stuff.
There's also another reason for that. And that would be, well, actually, I don't know if Kathy is referencing in the chat, but playing a video should be viewed in real time. You shouldn't be able to zoom in, slow it down, fast forward. You should view it in real time because ideally that is the sense that the people in the video have. So this one's a little different because you're kind of looking at lyrics. So maybe you want to replay it and you're like, wait, what exactly did he say there? But like when you think about Rittenhouse, the pinch and zoom and slow down the video, none of that should have been allowed. Not even in the courtroom, let alone in the jury room, just for them to fetter with. Although we got the right result, I think it was through a lot of inappropriate hurdles that were placed in front of the jury.
Or for instance, in the recent Delphi trial, where they played the original and then the enhanced video with enhanced sound, with close-ups, with not only close-up, with enhancement of the close-ups.
Well, I wouldn't know because it was a secret kangaroo court where the cameras were not allowed. So I'm gonna have to take your word for it.
Yeah. that is the reports that came out from that courtroom, at least.
Yeah.
That they played the enhanced one where they zoomed in on the bridge guy, and that in itself was also enhanced because
it was like, look at that shadow.
2017 phone with extremely pixelated, and then they enhanced that too. Folks, when AI or whatever was back then, they put in things the program believes fits. So it's also if you choose to enhance sound, they remove background sound. They put forward take away the distortion. Yeah, but maybe bits of that distortion is also part of that guy's voice. Maybe he has a very gravelly voice, and all of a sudden it's cleaned up. It's no longer his voice.
What was I editing something the other day, and I was trying to remove the background sound, and it ended up removing most of the one speaker. There were two speakers, and because it wasn't the person that was holding the phone, they were a little bit further away. Their voice was a little gravelly, and it ended up removing their entire sound. When all I wanted to do was like remove like the street sound and stuff. And it wasn't going to be a piece of evidence that I introduced. I just wanted to be able to listen to it so I could take notes. And then when I went back to the original during the deposition, I had my notes. And it completely removed the speaker's voice. And it happens. Or like my new video editing software just came up. Or it's not new. It's the one that I've been using for years. It has a new enhancement in AI enhancement. So if I zoom in, it will edit the video so that it's not as grainy and will be clear. Well, where do those pixels come from? It came from the brain of the AI. It doesn't mean that they actually exist.
Exactly.
Guilty yet? Yeah. Do we have? This is going to be a quick verdict, right? So they have today. They're going to come back with a verdict tomorrow. Is my prediction. They're going to come. They're not going to. They're going to want to go to the bars tonight. It's the Wednesday before Thanksgiving. Or not tonight, tomorrow, I mean. And so they're going to come back with a verdict either today or tomorrow. If it's tomorrow, I would say not guilty. If it's today, I'm going to say guilty. But they're not carrying it past Thanksgiving.
I'm hoping for OJ jury. 4 hours, not guilty.
Or if it goes beyond Thursday, it's going to be a hung jury. That's my prediction. I did a trial, and the way the schedule worked, we sent the jury back at like 2:00 the day before Easter. It was Good Friday, so we had a weekend. We had Easter Sunday coming up, and that jury was like, "All right, we got 2 hours to come to a resolution." And they spent like an hour. Like I had just enough time to get downstairs to the cafeteria, get set up to work on something else. And the judge called me and said, we got a verdict. Because they don't want to sit there during a holiday weekend and all of that.
Kathy asks, Are they even deliberating yet? I'm actually not sure because once the camera went off, they were still arguing what to send back, and if with any instructions, and with this and that. So let's skip ahead a bit to where we
they're back on the
actually
record.
was. We were around here. So
Not a
oh
demonstrative prepared by the state.
oh
Unless
they kept talking about it. Okay.
Hey, did you get my email, by the way?
Yeah.
Okay.
If you mean the
Video from yesterday?
this case,
Yeah.
Your Honor,
I got it.
it's,
Thank you.
I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKinsey versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator it was the DeKalb County DA's office based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule.
That's kind of,
I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness.
so is she allowing
Seems
it
okay
in?
to me.
I don't
I'm
know.
going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
Yeah,
So I
because
think
that by very
unless y'all come up with
definition
something
is
else
a
that I'm going to
statement by the
overrule
attorney.
the objection to both the CADA reports as described, redacted, and demonstratives going out. Other,
Okay.
So there are some pieces of physical evidence, Your Honor, hats,
okay,
other clothing items
yeah,
that we're having someone go to retrieve to bring them down.
okay,
And I think by the time we retrieve that, gather everything, we'll be ready to
all right.
collect everything and have it sent back.
One other matter, there are two demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial.
So I'm,
In January.
yeah,
I don't-
those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure. it's appropriate.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, it might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe, Mr. Atkins.
All right. Okay. Well, good. Thank you. So I keep. Hmm? Can we do that?
Why are they still going over stuff? Because this is the never-ending litigation case.
Yeah.
Yes. Hmm.
Oh,
Demonstratives were the result of his writing during testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it a demonstrative. Essentially, they were writing to encourage the jurors to write. Is kind of the way I saw it. Sending a message, write this down because it's important. but I don't believe it's appropriate for
I-
these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
So I'm gonna put these right here with the, not those.
Okay. All right, y'all can continue to do this. Let's take a quick recess though. And y'all do that during the recess and then maybe we'll come back and once it's settled, okay?
Yeah, and
Honestly, it could be our recess/lunch if you want it to be. So you want to come back.
recess plus lunch. But that's like, okay, so yeah. Stream ended 26 minutes. What? No.
That
Is it over? Is the case over?
No. They just started a new stream. Oh, Jesus Christ. Okay.
Oh, I got to make some phone calls. Let me see here. Do they have anything?
here or
Nope. All right, so they are talking. Okay.
Yeah.
right, joint exhibit.
Well, before that, thank you to Chicken Poo for gifted 5 memberships, getting our total up to 31 gifted memberships today. And technically, we are at 12 out of 15 $5 and more super chats. But with all the gifted memberships, we already reached the goal. And I will read an Old Norse saga as soon as we are in the app. As soon as we are that everything is handed to the jury, then we are on actual verdict watch.
But
I'm gonna,
one on here.
Sorry, I was just saying, I'm going to pop out. I got to make a couple of calls on some
Yep.
cases, and then I'll be listening and pop back in. But it is 1:59 in Georgia right now. Actually, it's 2 p.m.
2 p.m. Yep.
All right, I'll be back.
Yep.
That'll work for that. We've got copies of the redacted indictment to go out. We do not. We still have to sort out the language of those last couple of overt acts that we highlighted earlier. So can we figure that out? And
Okay. No verdict.
do we otherwise have all of the evidence that's going to go out?
Your Honor, there was a challenge during the lunch break to get into Judge Daniel's chambers.
Uh-huh. The deputies can get into anybody's chambers.
They just got it maybe about 5-7 minutes ago.
Okay.
So they're getting the evidence for a chain of custody form, so they're trying to get chain of custody form.
Okay, well, I mean, it goes from one court reporter to another, so do you want the court reporter to just walk up there and take possession of the evidence?
Yes.
That's probably the best way to do it. Then we don't need a chain of custody form. It just is with the court reporter. Yes, we'll do that. All right, so we will recess for our delightful new court reporter to do that. Thank you, Ms. Taylor.
Okay. Dun dun dun. And
Judge Glanville's chambers is going to, it's apparently a significant amount of evidence. They're going to basically wheel it down here to this courtroom and
I wouldn't trust anything that has been in Judge Glanville's chambers. Did John C. send me an email last night? Oh, yeah. But it didn't include a file or anything. So
Ms. Taylor, our current court reporter, is going to take possession of it. So that'll happen in the next 10 minutes or so. Can somebody, I guess I could do that, look in Odyssey and find out the date that's on the original re-indictment to put on this one? You know, when they signed, or who's got possession of the signed indictment? So that might still be, is it in here or is it still with, is it making its way downstairs? We need the date, so we need to see the.
Oh, maybe Glenville has to
Yeah,
watch.
I would think the case manager would have it. Right.
Yeah, I also wonder if he kept jewelry in his chambers. Yeah, that's a really good question. Why are there still evidence in his chambers? He was removed in June. Why are there still things belonging to this trial in his chambers? I can't answer that.
I assure you, it's in that scene.
Yeah, we are getting to that either
All right, have y'all
today
looked
or
at
tomorrow.
the highlighted language?
Hold on. We will get to Miss Hilton's ghetto moment yesterday, either today, if we find time for it, or tomorrow. But we will go through it during Verdict Watch. Because Miss Hilton, the sorority sister, the somewhat privileged upbringing, I'm more ghetto than Miss Hilton. And I'm the whitest person who ever lived.
For the proposed ways to handle those couple of overt acts as an A and a B?
Yes, Your Honor, and the state had a proposal to, I think, simplify
Okay,
the matter in terms of starting with 183.
okay,
If the state just redacted possession of codeine with intent to distribute and possession of cocaine, because this is the street gang charge, so the jury will still be tasked with the other revisions of did Arnold or Williams possess those items individually. So for purposes of 183, the state proposal is to redact where it only remains possession of marijuana with intent to distribute and possession of firearm during commission, which tracks the language.
okay. So leave all three of them and have those two kind of offenses only?
Yes, Your Honor.
Okay,
And for 187, the state's proposal is the same, to remove possession of codeine with intent to distribute and possession of cocaine.
okay.
Can I ask a question? So would that mean that we would end up with what?
What is essentially 187A and 183A,
Okay,
right?
thank you. That's what it seems to me, and I just want to make sure my.
But those
understanding is
wouldn't say
correct.
A anymore, they would
Right.
just say 183 and 187.
Yes, Your Honor.
Okay, yeah, that works if that's,
And the state, and I can email this, but with our previous discussion on the 133 charges, and the language, the state, if you stop, like, for example, take 189 or 190,
okay,
if you stop after an associate did commit the felony offense of possession of firearm by convicted felon, and then redline everything up to where you start by possessing a Glock, and then we would obviously remove for 189 specifically, we would remove the machine gun,
right. Okay,
and then just pick back up, possession of a firearm in indictment, and then cite the felony and the date, and keep an overt action furtherance.
that works as long as, so the question on the floor for that had been, can an overt act be modified to drop it down to a lesser, essentially? Do we have an answer to that?
Your Honor, I'm going to let Mr. Floyd
Okay,
address that with the court, because we do have a,
give me just a sec.
yes, Your Honor.
Yeah, I did not have evidence stored in Judge Glanville's chambers on my bingo card for this trial. And my bingo card had a lot of crap in it, but not evidence stored in the recused judge's office. That is insanity. Absolute insanity.
Yes. I wasn't here that day. Maybe I was here this time.
We took in this.
Thank you for your patience.
Of course not. So the approach we took in this, to try to avoid any problems, was only to remove language, not to add anything.
Mhm.
At least we added.
Right.
I want to be clear, is not exactly the same situation, but the most analogous thing I could find in the time available is 11th Circuit RICO case, United States v. Watchmaker, spelled exactly as it sounds, 761 F. 2nd, 1459 at 1468. It's a 1985 case.
Okay.
In that situation, analogous to this, the court found there were certain predicate acts for which no evidence had been presented. It removed them from consideration from the indictment that the jury saw.
Right.
That was held not to be a problem.
Okay.
And so here we're removing actually less. We're actually removing a subset of that as it references the specific individual defendant in whichever circumstance we're talking about. The others are not at trial. They would have no ground to complain.
Right.
They're not parties.
All right.
So I think it's on all threes at least. But I can't really find a problem with it because we restricted in this circumstance solely to deletion, not
Okay.
addition.
It would seem that, I mean, of course, I haven't had a chance to read this Watchmaker case yet, but if they're removing an entire predicate act, that would seem to be more analogous to removing the entire overt act rather than amending the overt act. But again, I haven't read Watchmaker. I'm just wondering if amending the overt act, we would be running into a constructive amendment claim, constructive amendment of the indictment.
Well,
Because-
two aspects. I didn't mean to cut you off.
No, please go ahead.
Okay. Two considerations on that, Your Honor.
Mhm.
One is the meaning of the word amendment in this circumstance. So if we were changing.
Let's see. The expert on RICO says something to the judge, the defense, who just got this case in their lap, is trying to argue. This is after the state's case in chief, after closing arguments. It's too late. In my personal, very biased opinion, if the state fucks up the indictment, they have had 2.5 years, 2 years since the trial was, since they claimed they were ready for trial. November of 2022, December of 2022, they claimed they were ready for trial. And now they want to amend things after everything is said and done? No. In my personal biased opinion, if they fuck up, then let them fuck up, judge. Just throw it out. Because they had all the time and resources, millions at their disposal. It's inexcusable to just let them amend things just because, things didn't work out the way we thought it would in the trial, so please let us amend it. No. You're done. The trial is done. The trial is over. The charges if it's not in the charges you presented for the jury in the beginning of the trial, it should be gone. And I heard her talking about fairness to the prosecution. How about this for fairness, Judge Whitaker? The same amount of money they spend are allocated to the defense. How about that? That would make this fair. If the defense had the same resources as the prosecution, that would be fair. They don't. If they fuck up, even though they have everything for them, too bad, so sad. Yeet it. It's pissing me off because there's only one person in a trial setting that has a constitutional right to fairness. It's the defendant. The prosecution has the money, they have the resources, they have the entirety of the state backing them. That is what they have. And all that the defense has is presumption of innocence and a judge that done. Don't help them.
Yet to refer to another offense or adding words, that would constitute an amendment. This, to the extent it's an amendment, is exclusively an amendment by deletion. And it is tailored.
Folks, it's just deletion. Well, we know what the state did with deletion. Mr. Atkins, with the statement, they're saying we killed not. He deleted the they're saying part and only played we killed not for the jury. That is how you change the meaning with deletion. It's altering no matter how you see it.
To those aspects where Your Honor found there was an absence of evidence. There's no prejudice to the defendant. It's favorable to the defendant. I'm not aware of anything that says you have to cut beyond the scope of where you found there was a shortage of a failure of evidence. I don't think there's anything that compels that conclusion. That there's, in other words, I don't think this is a throw out the baby with the bathwater scenario.
I would argue that the amendment is actually not favorable to us. That amendment by deletion actually broadens out that overt act. It does not work in our favor because you're removing the
I agree. It
elements.
doesn't work in the defense's favor to make it easier for the state to prove an overt act.
Yeah, and that thus it's conduct beyond that which would appear in the original grand jury indictment, and that would amount to constructive amendment.
Yeah. You know, I mean, even I'm reading Watchmaker right now, and part of it says the court did not change the terms of the crime with which Keating was charged, which I'm not changing the crime, but I'm changing the crime in the overt act. I think the safer thing to do is just to redact the indictment to remove those overt acts.
Yes.
I'm not convinced that it might not be error to do the way you propose. I think logically speaking, it sounds like it should make sense, but in the absence of something that makes it clear to me that it's not error, I would hate to borrow a term from one of y'all, get to, the 90, y'all haven't said it, but almost, I don't know, never mind. It was some kind of football field reference that I'm not going to be able to do right. So just never mind. The 1 yard line. And then, yes, y'all probably
I
said
thought
2
you were going
yard
to say
line.
risk introducing further error into this.
No, I don't know that there is error in this case at all. I don't know.
Okay.
There is typically, there are no perfect trials. We know that. It will be up to potentially some other court to determine that issue down the line. But right here today. I would hate to be on the now 1 yard line and do something that does cause an error that couldn't be corrected.
And so, Your Honor, if I can respond to that, two points. One, it's important, I think, to be specific as to which acts we're talking about.
Okay.
So with 183, there's no change in the nature of the crime. We're
Here's the thing. Why are the state arguing so hard on these overtax? Well, if you build a house and everything, and the thing that holds it together are thumbtacks, you need all the thumbtacks, all of them, or it will fall apart. You need as many as possible everywhere. That is why they are fighting tooth and nail to keep this particular thumbtack in there.
talking about striking out those specific things as source of evidence.
Right.
I can't imagine any problem from that.
Yeah, no, I agree. I was talking more about the possession of a firearm by the whatever they were, 174, 175, 189, and 190. I'm just going to redact out completely.
Okay.
With regard to 183 and 187, I think those are fine to have just gotten rid of the things that I directed a verdict in Mr. Kendrick's favor on.
Thank you, Your Honor.
And Your Honor, with regard to, I have 2 points.
Okay.
One is, when you're talking about, and forgive me if I get the number exactly wrong, but 170, I think it's 174, 175,
Mhm.
89, and 90.
Yes.
And so with those, the specter that's been raised is, to paraphrase the defense, the appearance of error where none currently exists, as we are at first and inches.
Mhm.
However, because of the way you have instructed the jury
Mhm.
to handle the overt acts, if they find these and if there's a defect, those in public court simply strike them from consideration.
Unless they're the only acts they find.
In which case we would know that as well.
All right.
Because they're going to number them.
Understood. I'm just gonna redact them. Y'all will still have over 100 overt acts.
Yeah, they have even with these redacted ones, they have over 100. The original was 196 overt acts. They have plenty to choose from, sadly. Thank you to Derek Crossan for becoming a member, and thank you to Chicken Poo for gifted 5 more memberships. That brings the total to 37 gifted memberships. And you all have now access to all my members-only content on the YouTubes, which is, I mean, yeah, we are talking about over 100 hours of content just for you guys. And your own emojis, and also access to my Discord. Let me post a fresh link to my Discord on the community section, only for members. Let's see, copy. Dun, dun, dun. Community tab, visibility, all channel members, the Discord. There. And a new fresh link is posted. Now, the Discord is for you guys. I log in once or twice a week just to check any questions, any suggestions, stuff like that. But it's mainly so you guys can get to know each other, discuss the cases I'm covering, this case in particular, and stuff like that. Yeah, Discord is, yeah, it's kind like Reddit, but the channel I have on Discord is only for you. It's not open for the public. Thank you so much for becoming members, and thank you immensely for the gifted memberships.
For them to evaluate. All right, so I am redacting out to delete 174, 175, 189, and 190. Don't know why it won't let me. And then on 183, it will be the language that is now 183A, but it won't say A, it'll just say 183.
And Your Honor,
And then the same with 187. Yes.
this argument may be fixed, but with both of those, of course, redlining or removing, the possession of codeine, the intent to distribute and possession of cocaine from the bottom.
Right.
The last version I saw on 183 and 187 still had those included.
Oh, it doesn't anymore.
I think the state may be looking at the B language and not the A language.
That's perfect, Your Honor.
All right. All right, I think I can't do the rest of it until Ms. Percival comes back because she has the same document up and for some reason it's not letting me remove the highlights. All right, I see that our mainly physical evidence has arrived from Judge Glanville's court reporter's office.
Oh, court reporter's office. Okay. But Miss Weaver, I like her. Did you know she is moving to another county? Yes, she's going to be a court reporter in a different jurisdiction. So we will not see her in Fulton County anymore. I don't know why she decided to leave, but I don't blame her one single bit. And it's still Judge Glanville's office. Yeah, she yeeted herself out of this jurisdiction.
And Ms. Taylor, our current court reporter, will take possession of it. And do you all know what's going out and what's not? Because the jury has had this case for an hour and a half now, but they haven't been able to deliberate because they're awaiting the evidence. And that is why I told y'all for the last several weeks to make a determination about what evidence was going to go out so that when they got the case, they could get the evidence too and begin deliberating. So I'm kind of ready for that to happen.
Don't blame all of them. This is on the prosecution and the prosecution alone. All right.
Look. All right, Ms. Percival has what we think is the final redacted indictment. So with the changes we just discussed, so if everybody can take a look at those, they start on about page 40 or so. Just take a look at those, confirm that they are what everyone has agreed we're going to do. And then if so, we'll print it out and that'll be ready to go to the jury as well. At which time, the last thing we will be waiting on is the evidence.
Yes.
Record, for instance. All right, while y'all are doing that, I'm just going to put on the record that with regard to the guns and any other physical evidence that's not going to go out with the jury, for instance, the drugs, the DA is the official custodian of that evidence, and so the DA will remain in possession of that evidence, and y'all need to keep that in your locked evidence room. The court reporter is not going to be taking custody of that, the guns and that other type physical evidence that is not going out with the jury.
I know, right? I'm gonna be doing both things.
Can some member from each team be dealing with the rest of what's just paper evidence and making sure that everybody is on board and on the same page with regard to that?
We've done that.
All right.
We just need to make sure I think we know everything. We just gotta make.
Okay, I am ready to hand all of this to the jury in the next 5 minutes. So whatever needs to get done, let's do it now.
This yeah.
I think that's extra holiday. That's just extra stuff. It just literally.
I'm going to be put over and we'll display it in the courtroom.
The juror, for whatever reason, they want to see a certain gun.
Then y'all will have to wheel it over and we'll display it in the courtroom.
So we can't keep them here while they're delivering.
No, no, I mean, they might deliberate for a month and a half. We might need to use, I'm going to be using this courtroom for the other defendants in this, on this indictment. So no.
Your Honor, Ms. Birchfield, these are, I separated these. This is investigator Dennis's stuff that was taken out.
Okay.
And Jimmy Winfrey, plea that was taken out.
Okay.
And a transcript for Mr. Sledge.
All right.
So these are all different things that were either removed from evidence, whatever it is.
Can you make sure that 444Y and 1AS are not going back? They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
Your Honor, I've looked at the revised indictment that we just received and it's acceptable to me.
Thank you.
Guys, do you know what why?
Why should we afford it?
What's interesting here will be if they ask for certain evidence they know should not have been in their possession, but some, I mean, mistakes happen from the defense. I will always assume it's intentional from the state, and they ask for it and they find it, or they say we have watched this. Then what? Is it a mistrial? Folks, all the way until the jury returns with a verdict. There can be plea deals and there can be mistrial. No, I don't think mistrial will happen because it would have happened up until then. But don't rule out plea deals. We don't know yet.
That may have been Mr. Sledge's pleas or something like that.
Yeah, it works. See it, it's right there. You cover it, sorry.
What was that number down line? 444. I think it's a, my screen has it. Let me go take one. Yeah. I mean, you have a small one.
Folks, I hope you don't think it, regardless of the verdict, that this has been a waste of time. We have learned so immensely much through this trial. The absolute corruption in the DA's office. Without this trial, would we have known? Would we have known about Shane Kendall? Would we have known about the other cases Ms. Love has handled where she put people in jail who then died in jail? No. So yes, we have learned so many things. And I will say this again. This is not over. Behind the scenes are 12 more defendants who have been rotten away in jail for 2.5 years now without bond, waiting for this trial to end so their trial can start. It's not over. Not by a long shot.
My traveling.
Yeah, and remember, Miss Love has actively tried in the past to become a judge. Imagine her as a judge. If you live in Georgia and you see her name on the ballot, I don't care if it is a porcupine on the other ballot. Vote porcupine.
Yeah.
I do not see one AS in here.
Oh, you know what, it's the same thing.
Okay.
So we don't have to worry about that.
Okay.
All right, and I'm just going to put on, Ms. Taylor, I'm going to put on the record that I realize if you put on the record for me, put on the record for me.
Okay.
Give me a second.
Okay.
All right, so 1AS that I referenced before, I've realized that is the exhibit number from Mr. Sledge's plea, and it's not the exhibit number for this trial. The exhibit number for this trial is 444Y. They were just the same thing. Yeah.
But 444Y would stay in that.
It's in evidence, but I don't think it would go out.
So that came in because that was checked for the ballot. What was the other number that you were concerned about?
They're the same. No, that was it. It was 1AS, but that's not an exhibit to this trial. So it was just the way that exhibit was referenced in Sledge's agreement. So don't worry about that at all. Okay.
I have one here somewhere.
Yeah. Okay.
You got that phone, you ready? Yeah.
All right. I mean, if we're ready to start wheeling it in, we don't have to have all 5 things at once. We can wheel in number 1, carry in number 2. I am.
He wants the verdict form.
They're all right there in the middle, right there. Yeah.
Here they go. That's all right there. That's everything. Oh, is that in here? Wait, the indictment is not there. The indictment's not there. The indictment. There is no indictment yet.
We have to print it out.
Have y'all had a chance to look at the redacted indictment? Yeah. Yeah.
All those demonstratives that are right there go? Okay. Thank you.
Your Honor, this is just for the purposes of the record.
Okay.
The state has reviewed the revised indictment, and it's going to be printed. I was just going to put for the record that the state would object to the removal of the 133 counts, overt acts, that are 174, 75, 189, and 190. Thank you, Your Honor.
Go fuck yourself, sad boss.
Is that where you went there, guys?
That's not what we got.
No, there's more. What is it?
She's waiting.
You have been so generous. I don't care if this stream gets monetized. So I'm going to use the words today.
Keep right here.
Thank you, guys.
You can use the lid, just don't give me that paper.
Oh, this is right.
That's the cover. Have a few things.
While the all right, while the jury is deliberating, Ms. Persfield's going to check to make sure she has a cell phone number for each of the attorneys.
Okay, so now you see all the evidence cards gone. So it's out to the jury. As of 14 minutes ago, they are deliberating.
Because obviously we have no idea when and or if they might want to ask a question or look at evidence. And so we all need to be on standby. We're all still in trial. And I need for people to be able to get here, in 5 minutes time. Ideally. If you have a special place you need to be, we can talk, but in short order. And obviously the defendants will continue to come over each day that the jury is deliberating, so that they can also be available to come to the courtroom if need be.
I apologize if the court has already stated this. When will the jury end their deliberations today, and what is the schedule for them tomorrow?
Oh, it's in what time?
Yeah.
Well, I have instructed them through the deputies that they need to stay at least until 5. If they want to stay beyond that, they're free to. Not past 7 ever, which I don't think they're going to want to anyway. But.
Jury deliberations, 9 to 5, at the latest 7. Now, I believe that indicates that if they tell the judge we are really close, then she will allow them to go to 7. If they don't, it's 5. So 9 to 5, verdict watch. But how does that go with Thanksgiving?
Oh, yeah, going back there. Oh, that'd be fun. Oh. All of this is like, all is done.
All right, and so they would like to continue to come in and start at 9, which is fine with me. So I'm going to say, just like a regular day, 9 to 5 with a lunch break. There will be days that the court provides lunch for them, and on those days they can choose to deliberate during their working lunch if they want to, or they can not deliberate and just take a break and eat. I'll make it clear that they can only deliberate when all 12 of them are there together. With regard to tomorrow, since it is the day before Thanksgiving, I'm going to say that they can leave at 3. And other than that, if there is some day or time that we need to alter that schedule, we'll just take it up as it comes.
And if they, I don't mean to ask for such detail, but if they decide to stay past 5, will we be notified of that so that we know to stay around the courthouse after 5? Or if they decide to stay after 3 tomorrow, will we be notified of that? I just want to make sure I don't leave the courthouse if they decide to deliberate late.
Sure.
If I have cell phone numbers for everybody, I'll do a fun group text chain and then text everybody what the schedule is going on, very briefly.
Thank you.
Juror number 56 is a deliberating juror. That was handled before lunch, but we will get there. We will get there. I have so much to cover with recaps. I still haven't watched Miss Hilton going all street on her rebuttal argument yesterday. So that we will have. And some of the jury instructions this morning, I haven't covered that. And then some highlights from the trial. I mean, depending on how long they will deliberate, we might end up covering the entire trial. No, we won't. Within this verdict watching, I will do more about the Fulton County Jail, more about Fonnie Willis, Nathan Wade story, the Ashley Merchant trying to get the documents from the DA's office, and also other cases in between. I might invite folks over to tell you about the cases they are covering and stuff like that during these verdict watches. So, but again, I have a day job. Sometimes I have to stay late, so I can't guarantee I will start immediately at 9 a.m. But I will listen, because if the moment I hear there's a question or a verdict, no matter where I am, if I'm in the car 500 miles right into the spinach, I will try to cover it. If I'm in a meeting, I will make that meeting very short. Oh.
No, Friday was already scheduled as a holiday date a long, long time ago. No.
May I approach?
Okay, so they will deliberate. When is actual Thanksgiving? When is actual Thanksgiving? Thursday. Okay. But they have Friday as a holiday. Does that mean they will deliberate Thursday? Let's go back and see.
I'll do a fun group text chain and then text everybody what the schedule, what's going on, very briefly.
Thank you.
No, Friday was already scheduled as a holiday date a long, long time ago. No.
May I approach?
Okay, so no, okay, thank you. So no deliberations Thursday or Friday. So there is a big chance it will be a verdict tomorrow. Unless they're caught up in something. I'm still hoping for an OJ jury, 4 hours and then not guilty. Okay, Wednesday was 3 p.m. cutoff. Okay, thank you, it's Trinton. Thank you. So a few hours today, 9 to 3 p.m., 9 a.m. to 3 p.m. tomorrow, and then it's a 5-day weekend, and then they will start again on Monday if they haven't reached a verdict.
On the record, after that. I'm going to make sure that we do this first and then I will. Yeah, oh exactly. That's hilarious. We're only using it once a day.
Chicken poo. Why is it called Black Friday? I'm Canadian. It just sounds evil. It's a made-up thing from Oh, let's pretend we are having a sale. Folks, if you have these price checking sites, check what the price was a month ago, and then check what they claim is the sales price on Black Friday. More often than not, it's the same price. They just jacked it up a week before Black Friday, and then they claim they lowered it. Court is closed Thursday. Yes. They have to be unanimous in any of the charges, and in the overt acts, I'm still not entirely sure if they have to be unanimous on one overt act or every one of them, or if they can choose one overt act each, as long as they choose to vote guilty on an overt act. I'm not entirely sure yet, because I've heard different opinions on it, so I can't say. What we do know is May 10th, 2017 is the cutoff point. Anything before May 10th, 2017, if they found, oh, the overt act of this 2013 whatevers, doesn't count. It has to be between May 10th, 2017 and May 9th, 2022, within those 5 years. Yeah, this is awesome, but they don't have to agree which underlying act they're using for the RICO. I heard both, and I must say, I'm not entirely sure. There are roughly 160, between 150 and 160 overt acts under the RICO charge. That's, yeah. And roughly I'm not entirely sure, but I'm still hoping for a not guilty on all of them.
Yeah, she's good. Yeah. It's, my printer decided to be crazy. It has a mind of its own, apparently.
They are deliberating now.
Correct.
They got the evidence carted into them, so they are actively deliberating right now. Oh, Law and Crime has a verdict watch going.
I know stuff. You got this. I'll get it here. It doesn't look like it. I swear. Oh, no, I get it. That's your system, so it doesn't have to look good to me.
So they have 2 rounds of deliberation today, and between 9 a.m. and 3 p.m. tomorrow. And then it's a 5-day weekend.
Oh, man. Oh, what a tiny baby. Awesome. I know, right? Sorry. Is it? Okay. Okay, thank you. We didn't say anything, but glad you told. We didn't say anything.
And we are in recess. All right, with that, that is everything. The jury has the case, and we are in recess until such time as we hear from the jury.
Jury is now deliberating. Let's see. And this is what they have on Law and Crime. All right, we are in actual verdict watch. Oh, wow. Did not. Yeah, it's a weird feeling covering this case since May of last year. I was, up until a few weeks ago, I thought this was going to go on until September next year. And it probably would, if not for that final mistrial, where Judge Whitaker said the words, "Unless you want a mistrial without prejudice." And somebody said, "Yeah." And then if a week later, 4 people had pled out. Only 2 left, Stilwell and Jack. And all of a sudden we are here. All of a sudden we are here. Law and crime, yeah, props for this trial. Huge investment. Clip Game has leveled up beyond anything I expected, and extra information on X. I must say, I wasn't impressed with their coverage up on somewhere around April, May. Something changed with the law and crime. And I think it has to do with their audience. Because all of a sudden, their polls started to go on not guilty. And then the Glanville situation happened. Yeah, and the Attorney Steele going viral. Yeah, definitely that. Definitely that. All right, where do we go from here? Well, this might be a good time to go back to seeing Street Hilton doing her rebuttal closing argument yesterday. What's going on now? I need to find it. Yeah. By the way, December 3rd, Judge Whitaker has scheduled a hearing for the remaining 12. That will be extremely, extremely interesting. Let's see here. Come on. Why am I having a hard time finding that? No, it's not 167 court. Well, 167 courtroom days, but you have to remove all the non-jury days. So I believe we have roughly 25 of those. Roughly. Then during Glanville, all the half days, which removes another 10 days. And then you have all the lateness, all the extended breaks and everything. Remove another 5 days. So 167 minus 40. So it is 127 actual court trial days with jury in a year. And it improved immensely with Yacht Whittaker. Remember, we were at day 80. Oh, let's see here. Where is it? Where do I have it? Copeland was day 87. So after Copeland, we had 80 court days. Tomorrow, it is exactly a year ago, November 27th, on the date since opening statements. So, well, technically, today is the 365th day. It's not a leap year, is it? Is it a leap year this year? Then it's 366 days. Oh, thank you, Sylvia Edwards. Gifting 10 memberships. That is so nice of you. Bringing the grand total up to 47 new members today. Thank you so much. That is so generous of you. That is so generous. Now remember, we are moving into Christmas holiday times. And folks, if I get a dip in super chats, gifted memberships and stuff, no worries. It's Christmas. It's time to think about family. I appreciate every single one of you guys. Every single one of you guys. And I have videos. Go watch it. I get some ad revenue. I'm fine, folks. I don't mind, but I'm fine. So if you have to choose between an extra Christmas gift to the niece, nephew, and a $10 super chat to me, choose a Christmas present. Folks, I'll be fine. January, or the other way, empty your fucking pockets. No, I'm just kidding. I'm joking. I'm joking. But thank you so much, each and everyone. And Sylvia, you have been so generous. I mean, for months. So thank you so much. All right. Oh, there it is. Okay. Finally. Boom. Who wants to see the Red Gang go full street? I only watched snippets of this, and I was told calling Miss Hilton going ghetto is kind of racist. Okay. I wouldn't agree with you, but... And yes, I have the stream right up there. So I will, if anything happens, I will switch right over to today. But let's listen to Streetwalker Hilton.
Good evening. I know y'all tired. And I get the harsh responsibility of closing you out for the next couple of, for a little while. I'm gonna tell you how long it's gonna be, but for a little while. And I just want you all to bear with me and bear with us as a state. Mr. Atkins told you this morning that it was kind of like that marathon. They were kind of at that last spot, right before the finish line. And I know this has been a long trial, and like every one of us has said, we thank you for your sacrifice. We know that we have taken you away from family, friends, trips, work, maybe I didn't want to work, but from work, to be here with us. And so we're going to ask of you just to bear with us for a little while longer. Now, Mr. Weinstein said something very interesting as he closed. He said something to the effect of,
Here, Miss Hilton will tell you her first lie.
the state should be ashamed of themselves for targeting people of color.
You lying piece of human garbage. That is not what Mr. Weinstein said. He said the state is only targeting rap music, black culture, not people of color. The culture. But that's the prosecution for you. They lie. They can't help themselves. They have to lie because if they start telling the truth, they don't have a case.
And I was a little taken aback. Why? Because I am a person of color. The majority of this prosecution team are people of color. And we are not targeting people of color. We are targeting gang members who decided to wreak havoc on communities in Fulton County. And the ironic part of the community that they violated were those communities were communities of color. See, no one rarely talks about the victims in this case. But the victims in this case, most of them are people of color. Because in Fulton County, you don't get to victimize anyone in our county without being held accountable for your actions. And what we're going to ask of you today is hold both of these defendants accountable for their actions. Because they are guilty of every single crime for which they are charged.
No, they're not.
But as both Mr. Shard and Mr. Weinstein were talking, I was reminded that what is right is often forgotten.
Like telling the truth, Miss Hilton?
And see, in this case for them, it's convenient to blame Kenneth Copeland for the murder of Donovan Thomas. Well, we're going to talk about that. That doesn't even make sense.
Yeah. He had means, motive, opportunity. And red on dark background is stupid. It is really hard for people with some kind of visual impairment to read. You ableist piece of garbage. Thank you, Chicken Poo. Gifted 5 memberships. Thank you so much. Getting our total up to 52. By the way, if you haven't noticed, this is a commentary channel. And I have things to say. It might not be for all of, but sometimes you need somebody who just say the words. And thank you, Chicken. I can't say the other word because that will definitely get me demonetized. I'm not sure if, let's see, I now have to count here. Let's see, 5, 10, 15, 20 gifted memberships from Chicken Poo. Do I have anything else? 20. Oh, I'm so sorry to Erin Passaretti, but Chicken Poo just got to a combined $60 and is now the new honorary Viking of today. Oh, I completely forgot. My deepest apologies. I'm not going to play this. You reached the goal, in my opinion. Now, 12 up to 15 in actual super chats, but with 47 gifted memberships, you earned it. Folks, the goal was for a certain amount of super chats, I would read you a story. Let's see if I can find a good one here. From Swedish folk and fairy tales. Let's see here. I can read about trolls and tomte, brave girls and boys, kings and queens. Let's see here. Let's find a good one. Hey! Mo's here.
Howdy, howdy.
Hey! Hey! I was just about to start reading a story.
Oh, cool.
From Swedish folk and fairy tales. And by the way, thank you to Sylvia Edwards for 5 more gifted memberships. That is amazing. Oh, we're up to 57 gifted memberships during this stream.
So have there been any jury questions? I've been trying to keep up, but I was
not yet.
Well, listening to my son get his teeth drilled.
They have been out for 37 minutes. Nothing new so far.
Wait, it took till today to finish closing arguments, or was it jury instructions?
Jury instruction the entire day, and then they have.
Holy God!
They argued about jury instructions, and then what evidence was supposed to go back to the jury, they have been arguing it up until 40 minutes ago. All right. I decided on this story. Let's see here. Let's do like this. Let's see if we can see it. The trolls and the youngest tomte. Now, tomte is what you in America would call a house elf of sorts.
Oh, so a brownie. I think that's an English term, but brownies are kind of house magical creatures that stay and they cook and they clean and you put brandy out for them. And I'm like, yeah, can I get one or 12? I have booze. Come clean for me.
All right. Let's see here. I don't have. In a storehouse on a small farm at the edge of a wood lived 3 tomtes, Charfa, Torgus, and Chovik. They were part of an old tomte family that had lived on the farm for more than 900 years. The farm had changed owners many times. Old people had gone away and new ones had come. But the Tomte family had faithfully remained, and the honor of being the Tomte who looked after the farm passed from father to son. The little storehouse was situated prettily between hilly pasture land and a dense dark forest. In the forest was a steep, craggy Foxhall mountain. 2 trolls lived there, Jompa and Skimpa. The troll king of the mountain and his wife. They had lived there long before people moved in alongside them and were 4,000 years old. The Tomtes and the trolls had always been bitter enemies. The trolls were large, strong, evil, and stupid. The Tomtes were as small
So
as dolls.
the prosecution team.
Yeah. The Tomtes were small as dolls, but kind and very intelligent. The trolls wanted to hurt the people on the farm, which is why the Tomtes hated them. They were always fighting. Sometimes the Tomtes won, sometimes the trolls. It could not be otherwise, since it was a battle between strength and intelligence. Now it was Christmas Eve, and a feast was being held in the storehouse, where grandfather Tomte, Charfa Jorikson, lived between a couple of flour barrels. It was the old one's 500th birthday, and his birthday and Christmas were to be celebrated together this year. Grandfather Charfa was brisk and active despite his age, but had recently retired and handed down his authority to Torgus Charfson, who was 300 years old and in the prime of his life. The youngest Tomte, Torvik Torgason, was a boy of only 100 years. He did not even have a Tomte beard yet, and he scarcely reached his father's shoulder. All the Tomtes in the region had been invited to the party, and they were all in high spirits. The storehouse was well stocked with apples, loaves of wheat bread, ham and sausage, all spread out on a small table that was really an upturned sugar box. The farm people knew that the Tomtes were careful, never wasting so much as a spoonful of flour. Now, grandfather, tell us stories about Skimpa and Jompa, said Sjovik, climbing up in the old Tomte's lap and stroking his long white beard. Well, my grandson, said the old Tomte happily, sit still, and you shall hear about how it used to be. All the Tomtes made themselves comfortable. Some lay on the floor, hands on the shins. Others sat and dangled their legs from anchovy tin chairs. Old Charfa began. I shall tell you how it was 800 years ago, when my grandfather, Tarja Torgesson, was in his prime on Foxhall Mountain. People had decided to build a church on the plain, but the trolls were angry about it. So every night they tore down what had been built the day before. But the church was built, wasn't it? Said little Sjovik. It was indeed, and it was grandfather Tarja who helped build it. He filled a bag with ashes and climbed a tree growing on the mountain. When the trolls came out of the mountain at night to throw boulders at the church, he threw ashes in their eyes. And the trolls could not see the church, cried the delighted Tomtes. They could not. There was an outcry from the trolls, who threw their boulders but never hit the mark. Poor Jompa, giggled the boy Tomte. And so the church was finished, continued old Chorfa. The bishop blessed it, and after that the trolls could not damage it. But they were all the wilder in the forest. At that time there were wolves and bears, and the trolls encouraged them to attack farm animals. Grandfather always had to fly back and forth like a shuttlecock to help the farm folk. Did the trolls ever catch him? Asked Shovik. Oh, yes. Many times they took him into the mountain, but he always tricked them and escaped. Sometimes he came out sooty and scratched, but other times he brought out more gold than he could carry. Do the trolls have gold in the mountain? Asked Shovik, surprised. The other tomtes laughed until their beards shook. It's clear you're just a child, little Shovik, they said, or else you would know that Foxhole Mountain is full of gold and jewels. No, don't tell Phony Willis about Foxhole Mountain and gold. Really? Exclaimed the boy Tomte. Then shouldn't we go and get some of the treasure? The poor people around here need a few luxuries to brighten their lives. No, my little boy, said his father crossly. Troll gold is never a blessing. Oh, by the way, if it's never a blessing, Phony, go get it.
I was about to say, let's make it rain up in this. I need some troll gold. Go into Fannie Willis's house.
Troll gold is never a blessing. It only leads to pride, laziness, greed, strife, fighting, and hatred. My grandfather taught me this early, and for that reason my father and I and all the tomtes here have left the mountain gold untouched. It must be hard to find anyway, mused Shovik. Well, tonight it would be easy, replied the old grandfather. On Christmas Eve, the trolls bring out all their treasure to count it. And they are so eager and excited that they don't notice a thing around them. But how would someone get into the mountain? Asked Shovik. On Christmas Eve, the mountain doors swing open by themselves, was the reply. But woe to anyone who is still there when the church bells ring for matins. Then the trolls both see and hear, and you are trapped. Did your father ever have trouble with them, grandfather? Jovik Tarjason, I should say no. Once he was within a hair's breadth of losing his life. That time he rode an ox out of the mountain. What happened, dear grandfather? Tell us, tell us. Well, you see, Skimpa had stolen the ox from the farm. My father was furious, so he crept into the mountain. It was easy, for the troll woman had forgotten to shut the door. Jompa was standing there with an axe raised over the head of the ox, ready to kill it. Well, father was bold. He climbed up the ox's tail and pricked its back with a pin. The ox jumped, knocked over both Skimpa and Jompa, and they fell on the floor with their feet in the air. And then the ox tore out of the mountain door with father on his back. The tomtes laughed so hard that two of them fell off their anchovy tins. And you, grandfather, have you ever been inside the mountain? Asked Shovik. Many times, but I've never taken anything from the trolls except what they have stolen from our farm people. Once I barely escaped with my life. I lost my red tasseled cap and my wooden shoes and had to go up the chimney to get away because the door was locked. I came home sooty as a sweep. My brother had the same bad luck a few years ago, said another tomte. What happened to him? Shovik asked. He was trying to find a young shepherdess whom the trolls had carried away, and he was in the mountain when the rooster crowed. They use another word for rooster here, but
I think Fanny's
I don't need
acquainted
that
with that too.
I don't need that imagery. Oh, by the way, screw it. Let's read that line as it is written. He was trying to find a young shepherdess whom the trolls had carried away, and he was in the mountain when the cock crowed, and all the doors shut with a bang. There was nothing for him to do but throw himself into the mountain spring and go underground with the stream. The brook that flows through the farm had its source in the mountain, you know. The poor man was soaked to the skin when he came home. The young tomte listened to all this with the greatest interest. He would very much have liked to snatch a bracelet or a good golden chain from the trolls to give to Anna-Lisa, the farmer's oldest daughter, who was soon to be married. She was good to everyone, and Chovik wished her the very best of fortune. The tomtes sat and listened to old Charfa for a long time, until at least they all became sleepy and trooped off home. Grandfather fell asleep on an old mitten in a corner of the storeroom, and Torgus and Chovik lay down on a mat between a couple of sugar boxes. But the young tomte couldn't go to sleep. He was wondering how he could fetch Anna-Lisa a treasure from the mountain. Just one. Surely there could be no harm in that. Surely it was only when you took too much gold that you became wicked. At last he sat up, put his cap on his head and his wooden shoes on his feet, picked up his little stick and set out for the forest. The night was dark and silent. Not a star winked from the heaven, and not a gleam of light shone from any of the cottage windows. Everything dreamed in a deep, quiet midnight sleep, and only the drawn-out howl from a fox could now and then be heard from the forest. The tomte boy trotted along quickly. He was not afraid of the dark, and did not care about the fox. When you have legs only 3 inches long, you cannot go very fast. And the little tomte took 5 steps for every one a human would have taken. Yet he did make progress, and in an hour he was at the foot of the Foxhowl Mountain. My, how craggy and steep and high it rose. From deep inside there came a tinkling, clanking sound, as if someone was rattling and jingling gold and silver coins. You just wait, said Chovik, and began to climb the mountain. It was slow going, but he managed it somehow. Sometimes he slipped, but then he took a fresh hold and climbed higher and higher. Breathless and hot and sweaty, he climbed from crag to crag, rock to rock, and swung himself up one ledge after another until he was halfway up the mountainside. An owl hooted from a nearby grove, but Chovik could not let himself be scared. He would climb until he found an opening. At last he saw a faint light through a small crack in the rocks. He poked his little stick into the opening and twisted it. The door must have been well greased, for it opened slowly and soundlessly on its hinges. Now the little tomte entered a vast hall of rugged black stone, with rusty weapons hanging on the walls. He saw the bones of big cattle here and there on the floor, and it was dismal and gloomy. He walked on. He came to a second door, which seemed to be made of copper. It opened as easily as the first, and Chovik stepped into another hall. Silver coins were heaped against the walls, but not a creature was in sight. Surely there's enough money here to buy a watch for the good farmer, he thought. But wait, what is that tingling and jingling on the other side of that silver door? I wonder what they are doing in there. He paddled silently to the silver door and opened it. And what did he see? An open chest in the middle of the floor and 2 terrible trolls sitting beside it, jingling and rattling gold rings, bracelets, pearls, and precious stones. They were so busy counting their treasure in their chest that they neither saw nor heard Chovik enter. On the far side of the hall was a well, where water rushed up from the rock and earth below. An old cracked wooden shoe was in the well, tied to the wall with a string to keep it from being washed away. Skimpa must have put that wooden shoe in the well to make the wood swell, thought Chovik. I could always sail away from here in that if the doors are closed. He approached the chest quietly and carefully, but to him it was so high he could not reach the top. He stretched and stretched on tiptoe as far as he could, and then what do you think happened? Jompa and Skimpa sneezed, both at the same time. My goodness, how it echoed through the mountain. The sneezes lifted the little tomte into the air like a feather, and he landed head first right in the middle of all the gold in the chest. It's all over now, thought Chovik, holding tightly to his stick to defend himself from the trolls. But those stupid trolls had not seen him. They just kept counting and counting. Chovik looked around at all the gold and treasure. He picked out a chain just long enough to hang around someone's neck and tried to climb to the edge of the chest and jump to the floor. That was when all the church bells down below began to chime, calling the congregations to morning prayers. Both trolls jumped up and stuck their fingers in their ears. Then they closed and locked the mountain doors and slammed down the lid of the chest on the gold and on the little tomte boy. Poor Chovik sat there like a mouse in a trap. But he was not the one to lose courage easily. If I can trick the trolls into opening the chest again, I can get away, he thought. He put his mouth to the keyhole and began to squeak like a mouse. There's a rat in there, cried the troll woman. Let it stay till next Christmas for all I care, said the old man. Then it will gnaw a hole through the chest, the woman replied. You might be right, her husband admitted. And so they opened the chest again and saw the little tomte sitting near the edge. My, what a funny little rat, said the troll, and laughed until his belly shook. What kind of snippet are you? I'm Chovik Torgason, a tomte from the farm, Chovik answered fearlessly. Laughed the troll.
Why do I imagine that's Fannie Willis's laugh? I mean, I haven't heard it, but kind of sounds like.
I don't think she can laugh.
Yeah, I was going to say that requires a soul. I don't know.
Yeah. And took Chovik between his thumb and forefinger. He will make a fine dessert after the Christmas ham. Have your frying pan ready, mother? You can't fry me before I wash off the dirt off my fingers, said Chovik. Hold your tongues, warned the troll. You'll be washed all right, and you can be sure of that. And he put the boy on the brim of the well and poured water all over him. I'm still dirty, Chovik cried. You had better get a scrubbing brush and some soap. You're a fussy little man, grumbled the troll. But he loosened his grip and went to fetch a scrubbing brush. Instantly, the tomte jumped into the wooden shoe, opening his knife and cut off the string that anchored the shoe to the wall. Hey-ho! Right away, the wooden shoe began to float on the stream that flowed down the mountain well. Jompa and Skimpa howled loud enough to break your eardrums, but the little tomte just waved his pointed red cap and called, Hooray! The rabbits carried him and the wooden shoe through an underground channel and out again into the brook that ran by the farm. There, Chovik jumped ashore and made his way home. But he had no treasure. He had dropped the golden chain when the troll dashed water over him. It was the close thing whether Chovik would get a good thrashing from both his father and grandfather for his foolish adventure, but he escaped punishment because he had never done anything wrong before. He had to promise never again to look for treasure, except for that which can be earned through honest work. And this is a promise he has never broken.
Aww.
So,
I like how he's like one of my kids. My youngest, most feral, would be fearless and go up to anyone and be like, "Hi, my name is Feral. Feral Gump."
Let's see. Just checking here. Yeah, nothing happened in the trial.
So, having watched the trial, do you have any? I know we always do this, like, I think they'll be back, or I think that'll take time kind of thing. Do you have any guesstimations, or are we winging it?
I mean, the jury instructions are not probably more damning than anything the state put forward in their case. But for you folks who don't know, jury instruction, why are they so damning? Well, jury instructions are standardized. There's in almost every county and almost in every state, there is a panel of attorneys that meet up every now and then and decide how to improve jury instructions. Those are almost exclusively prosecutors. So you would imagine when they improve jury instructions, they improve it to make it easier to convict. So once in trial, judge brings out these standardized, and then they adapt it to the current trial. And then it is damage control from the attorneys, because they have to. And no matter how you polish that turd, it will always sound bad for the defendants. Always. And next time I have Steve Gosney on, I will ask him, and he will tell you, oh, he has some stories. He has some stories. And that is why most people who haven't watched the trial before listen to jury instructions and think, wow, that sounds bad. Yeah, because it's prosecutors who makes them, the standardized. But here we are. And it's awful. And as of now, we can't do anything about it but to put our hope into Max and Doug that they managed to counteract the most wild ones. Oh, are you translating in your head to read in English? No, this is already translated. Thank God.
I was wondering, I was like, that's a feat.
Now, I have this book also, Nordic Gods. This is in Swedish. So if I ever read from that one, then I have to translate in my head. Is that the Art of War collection beside the cat? What? Oh, no. This is for Christmas. I bought a lantern of sort. It's a leather lantern, so it's not a real lantern.
Oh, that's cute.
Yeah. It is LED musical snowing lantern. I could not help myself because I'm a sucker for Christmas.
Oh.
If it makes sounds and blinks and stuff, I need it. I need it. I have boxes over there, but that's last year.
Oh, believe me, once we get done with Thanksgiving, the kids are like, let's pull out the Christmas stuff. And you're so full of food, you don't want to do anything. And it's like,
Squad Bob, few knew that Nick was actually a blue wizard from Lord of the Rings. Yeah. You caught me. You caught me. When the blue wizards exited the story, I was born.
Now I just see Nick saying, I fuck, and then just wandering off.
Yeah, I'm making
the
blue wizard with the strong language. Blue wizard, where are you going? I am doing an off I fuck. This place dangerous. I could hurt myself. Oh, lovely story, Nick. Thank you. Oh, thank you. I didn't write it. I just read it. I have a channel where I read stories, but I haven't updated it since this spring.
Oh, that makes me feel better because I have orphan channels that I've made too. That I'm like, one day, children, I'll get back to you.
Thank you for the storybook. You're very welcome. It is called, I think it's on Amazon. I don't have an Amazon store, but this is on Amazon, Swedish Folk and Fairy Tales. And it's illustrated by John Bauer. Well, John Bauer's illustrations are in it. And John Bauer is probably one of the most well-known illustrators of old sagas and stuff. Let me show you one of these, if I can.
Oh, I like that style. I think you've shown one before that was in that style too.
Matt's asked, anything from the jury yet? Nope. Nothing yet. We are an hour and 11 minutes in. And no question, no nothing. I wouldn't be surprised if they just taking a vote, and if anybody says guilty, okay, let's talk about it. I don't expect anything to happen today. I hope something will happen, but yeah.
Do you know if do they have like a cutoff time? Are they going regular court hours, or is this one where they can stay as late as they want?
It's 9 to 5 with an option to go to 7.
Oh, okay.
Celestial Force. Nick, you made me go back to being a kid, even for a moment. Oh, thank you. That is actually really, really nice. Yeah, 5 today, 3 tomorrow, and then they have Thursday and Friday, and then they start over on Monday, if they haven't reached a verdict tomorrow.
This is bad to say, and I don't want to impugn on the jurors, but I don't see the jurors being gung-ho to stretch this across the holiday. And that does worry me. That seems to lead to a more compromised verdict sometimes. And I do worry about that.
Yeah. It's hard with jurors. I mean, with the Delphi trial.
Oh, yeah.
And a year and a half ago, we had the Zachariah Anderson trial. And it's absolutely unimaginable. Now, in Zachariah Anderson's case, at least the judge was only stupid. In the Delphi trial, Judge Gould, her extreme bias makes Judge Glanville seem like a saint in comparison.
I am so shocked that I did not vote to keep any of the current members of the Indiana Supreme Court or the AG in power. Now, I think I was part of a very big minority because they're still there. But I didn't put my support behind them after how they handled this case or how their agents, people under their authority, handled this case.
Yeah. I don't know what to say.
It's Indiana. We're very, very intoxicated on high fructose corn syrup, so apparently things get by us. So was I only got to listen to the first defense closing statement. Was the next defense lawyer that came up, was he able to do as good a job as the first lawyer in his closing? Because I thought he was exceptional, in my opinion.
Did really, really well.
Okay.
I think.
Well, that's good. I need to watch it. But last night I was taking a bajillion and 12 pages of notes to review a new docu-series about the John Benet Ramsey case.
Yeah. I mean, some things just makes you go very, very sad.
Yeah. And I think that this verdict watch time is kind of where you sit and you marinate and you think about, say you really believe the state or you really believe the defendant, you marinate on either the injustice or justice happening. And it's It's a lot realer than when you're just kind of critiquing, how people are performing in court. And it does give you time to marinate and maybe bring more feelings in, I think. Although the Jose Ibarra case, we had about 15 minutes, and the judge was like, I decided. Which, I mean, honestly, what other conclusion was he going to come to? Unlike what the media states, it's not because Jose Ibarra just could not get a fair trial. It's because he was all the guilty. I mean, there's not much that you can do when you have your hand or your fingerprint, your DNA, and just about left a calling card near the homicide.
Doug managed to troll Hilton into perfection and have her go into tirades of race. Yeah, one of his final remarks was that why does the state only prosecute lyrics from black culture? And Hilton, one of the first things she said, we don't target black people. That's not
Have you
what
been
he
to
said.
Fulton County? I mean, I get that it's a greater, density of the population, so but seriously, you've got people in Fulton County that have waited 10 years for a bond hearing. You don't target. Okie dokie. Did she go into the preacher voice? Did we get the full-on church voice?
She went street.
Oh.
I had another word for it, but Twitter told me that was racist.
Okay, call me naive, call me crazy, call me a Pollyanna, but isn't this lawyer the same distinct coloration as the rest of the defendants? So how could you use that card?
Well, Doug Weinstein is not black. And Miss Hilton took very hard offense to him even getting close to. But they have been arguing that throughout this trial. Why are you only targeting rap lyrics?
Well,
but he extended it to why only targeting black culture.
Yeah, I mean, let's call a spade a spade. They're not going after, Cletus von Cletus, and his new Zydeco band called, something. They're not going after any of that. They made a point to put all these rap lyrics in. They made a point to, denigrate this culture. Now, it's not something I'm familiar with, but they basically made everything that these gentlemen did a sign of guilt from, let's say acknowledging an affiliation with a group that does music or appreciating a guy that had a win story. So they, tattooed themselves. What there is a distinct use of this as character evidence and character flaws. So you are in fact critiquing and denigrating this culture.
Will I be quoting Swedish death metal lyrics anytime soon? No. Swedish or Norwegian death and black metal music. Let's just one of the bigger songs back in 1989, 1990, somewhere around there, was called Drep de Kristne, which direct translation is Kill the Christians.
Oh.
So no, I will not read that lyric.
It is worse than when I read the lyrics to WAP.
Yeah. And for you who don't know the Norwegian black metal scene back in late 80s, early 90s, there were a good amount of murders and burning of churches.
Well, what else are you going to do when you don't have cable, Nicholas? It was entrapment.
Mm-hmm. one of the more famous album covers is from a band where the singer went home to the drummer and found out, oh, he offed himself with a shotgun. Let's take a picture of it and use it as an album cover.
Well, it didn't work in a Kurt Cobain revival band either, so, I mean... That would be like Courtney Love putting that picture on her next album. Giblets.
Mm-hmm. Yeah.
So, are you going to be doing any streams while the rest of us fatten ourselves up with all the carbohydrates in the entire world?
Well, I have, let's see here, it's almost 4 p.m. So I expect something. I mean, I don't expect them to go past 5 p.m. today. Now, if they show up at 5 p.m. and the judge says, well, they're asking for more time, then we know a verdict is probably close. Will I stream during your eating hours? Well, we don't have Thanksgiving here, so I can find something to...
Nicholas, how did you meet the pilgrims?
Well, to be fair, my ancestors...
I'm pretty sure y'all came to America first.
Yeah, my ancestors took landing about 500 years prior to your ancestors.
Yeah. Again, I have always told this story, but it is always hilarious to me because my mother got 23andMe to prove to me, because I have always been myself as a child, and she has always claimed that, like, I have, you know, something percent Cherokee princess in me. And I looked at my mom dead in the eyes and I said, Mother, in what Nordic country did my Cherokee tribe come from? Because I was like Children of the Corn blonde, and, you know, still can't be in front of a 100-watt bulb. Anyhoozle, turns out that we might not be as Native Americanly endowed as we should be. But I still have more than Elizabeth Warren, so I'm not sure where that puts me on my congressional run. We need to get Dave to call the court and tell them to verdict faster.
Bondian will be watching horror movies all day because there's nothing else to do here. Okay.
Well, you should start by watching Die Hard. It's now a Christmas. I mean, celebrate the season before you get assaulted by Mariah Carey and All I Want for Christmas. She's being cryogenically unfrozen right now to assault our audio, you know, orifices.
Oh. Well, that's a great idea. Wait, where did it go? In the future, maybe Simone Hilton will be quoting death metal lyrics to support her "I'm not prosecuting rap lyrics" argument. Yeah, or maybe in the future, a defense attorney will say, oh, do you want to hear lyrics? Here is a song by the Norwegian black metal band Troll, and it's called Kill the Christians. And what do you know? One of the members allegedly went on a killing spree. And burnt down shit. Yeah, there was a lot of things happening in the late 80s, early 90s.
It was a simpler time, but it was, you know what was strange watching, or delving into the docuseries about John Benet Ramsey, maybe my 12-year-old self, when the age I was when this case came out, didn't realize how bad the media was. But looking at the media frenzy then and what we see in these cases, like the YSL, the, media going out and, just shading guilt, or implicitly stating it. Nancy Grace, I'm looking at you. Again, I didn't know that Ursula could be so far away from the sea.
Well, she put a spell on herself and grew legs.
Yeah, I had to see that Dancing with the Stars. I'm still traumatized.
If I'm ever want to really grift, this new goals thing in the chat, I will have $50, 20 of them, or I will play a Nancy Grace video.
Pretty sure Geneva's going to call you. That is cruel and unusual.
Yeah. But I had this lined up, by the way, before I started reading. Yeah. This is Miss Hilton. I will go back a few minutes until she actually starts here.
Again with the red. And why did Miss Love not do this?
This is from yesterday. It's the same day, but I just cut out a bit early.
I am shocked that Miss Love didn't do the rebuttal.
I think she wanted to, but she wasn't allowed to.
Okay, am I speaking out of turn? Is she pregnant?
No.
Thank you very much. All right, Miss Hilton.
She's been like that since the beginning of the trial.
Oh, okay, then I'm sorry, ma'am. But I'm never going to Georgia, so.
And I get the harsh responsibility of closing you out for the next couple of, for a little while, I'm gonna tell you how long it's going, for a little while. And I just want you all to bear with me, and bear with us as we speak. Mr. Atkins told you this morning that it was kind of like that marathon. They were kind of at that last spot, right before the finish line. And I know this has been a long trial, and like every one of us has said, we thank you for your sacrifice.
At opening statement, Ms. Love said, "You will be here for several weeks." Yeah, well, 52 weeks is several.
When you have to get a W-2 from jury duty, that's too long.
We know that we have taken you away from family, friends, trips, work, maybe not in one work, but from work, to be here with us. And so we're going to ask of you just to bear with us for a little while longer. Now, Mr. Weinstein said something very interesting as he closed. He said something to the effect of, the state should be ashamed of themselves for targeting people of color.
Which is the first lie. That is not what Mr. Weinstein said. He said the state is targeting only lyrics from Black culture, as in rap.
Well,
And
yeah,
said,
I mean,
no,
this is the same thing like in the late 80s, early 90s when they tried to get all the, heavy metal. It was causing all the Satanism, the Dungeons and Dragons. I mean, that's specifically targeting a culture and shading it for your political use. This is shading a culture for your political use.
Yeah, and I mean, it's the same as in targeting video games. Oh, it's indicting this and that. I mean, if these video games were so effective on our minds, we would all be listening to repetitive music and eating small pills.
I'm still pissed off I don't get a jetpack and a flying car. The Jetsons lied to me.
Yeah, and I mean, the future in Back to the Future was 8 years ago. Where's my hoverboard?
Okay, so Tim Wilson is a good comedian singer, and he has a song that's called, or the lyrics are basically, "Where the F is my jetpack?"
Mm.
And I was a little taken aback. Why? Because I am a person of color. The majority of this prosecution team are people of color.
And still you go after lyrics, rap lyrics.
Well,
No other lyrics.
should you waste your time as a prosecutor delving into insults that or slights that you feel from the defense, or should you go to your evidence, which is non-existent, but would you go into your evidence?
Yeah. This leads me to believe it was intentional from Mr. Weinstein. He knows how he phrased it.
He probably knows she has a thin skin. He probably has, he's been with her for a year.
2 years.
Oh, yeah, 2 years.
Pre-trial, yeah. And there are a majority black people on the jury. Now, it's a big gamble, because if they took as much offense as Miss Hilton did, yeah.
And we are not targeting people of color. We are targeting gang members who decided to wreak havoc on communities in Fulton County. And the ironic part of
Unlike you and
that they
Fanny?
violated were those communities were communities of color.
Yep. When it comes to closing arguments, the best closing arguments are pre-planned. From the very beginning, both opening statements and closing statements are pre-planned. You know the evidence you want in, and you know where it's leading. She just changed her mind from that one comment from Doug Weinstein.
Yeah, but so from what you've said, they've not brought in a single bullet. They've not brought in a single force multiplier. They've not brought in a single piece of physical evidence, even a fingerprint, anything like that. They want them to be charged based on whatever Slack means. And Slack, I have no idea, but a couple of text messages, videos, different things.
Yeah.
People brag on the internet. They don't, I mean, if you want to get some street cred, maybe you would brag about something you didn't do.
Yeah. And here's the thing with Georgia RICO. An overt act doesn't even have to be a criminal act.
See, no one rarely talks about the victims in this case. But the victims in this case, most of them.
Here comes the feelings. Oh, sorry.
Because in Fulton County, you don't get to victimize anyone in our county without being held accountable for your actions. So what we're going to ask of you today.
The absolute majority of all charges has already been through the system. People have been convicted. People have taken plea deals, or the charges have been dropped. This is the Georgia RICO. In this case, is a second bite at the apple. A trial by quantity.
Yeah, and the jury is going to have to parse out every note that they wrote, you know, involving these two defendants in the larger trial, and then also this case that they presented as well.
Is hold both of these defendants accountable for their actions, because they are guilty of every single crime for which they are charged.
No, they're not.
But as both Mr. Shard and Mr. Weinstein were talking, I was reminded that what is right is often forgotten or what is convenient.
The defense case.
Oh my God, did she just...
This slide was done when they actually thought there would be a defense case in chief. There were none. But
Did
they
she
couldn't
just-
change it. They have so much invested in this.
Did she just pull a B. Ivory Lamar and start with a quote like American History X?
Yeah.
You remember the Theodore Edgecombe trial where B. Ivory Lamar was, that puffed up, small claims attorney who decided to do a murder case. And he started with like these ridiculous quotes.
Yeah.
It was first year speech writing. Start with a quote.
Yeah, at least she's not quoting Rudyard Kipling.
Yeah. Or a rap lyric. That would have been funnier.
Yeah.
And see, in this case for them, it's convenient to blame Kenneth Copeland for the murder of Donovan Thomas.
Yeah, because he has means, motive, opportunity. I don't say he did it, but comparing them, it's damn more probable. But he got immunity, and now he's out and about.
Okay, is Kenneth Copeland Little Woody?
Yep.
Oh,
For
okay.
them,
I was
it
just
is
making sure I got the
convenient to
names
tell you that
right.
we have not met the elements of RICO because they're just not a gang. They just get YSL tatted on them. They just get snakes tatted on them just for the fun of it. That's convenient for them, but that is not the truth. And while it may have taken some time for us to get all that evidence out here, it took
Sometime.
a while. Some days the evidence came out good. Some days the evidence came out bad. Some days I had to take a couple of breaks. At the end of the day, the evidence shows what is clear. YSL is a gang. YSL is an enterprise. They commit criminal street gang activity. They murdered Donovan Thomas, murdered Chanel Drinks, and they're guilty.
If you have the law on your side, do the law. If you have the facts on your side, bang on the facts. If you have nothing, bang on the table.
This woman is the meme. Oh my goodness.
And then I'm also reminded of a story that a colleague told me a long time ago.
Lie
Oh
number
God,
2.
more personal stories.
No, this is not a personal story.
Oh,
This is a well-known story that is taught in law school. But she's
Oh.
presenting it as a colleague of mine.
oh, okay.
Yeah, this is an old joke.
About someone who works as a border patrol officer. And this person worked as a border patrol officer for a number of years. And while they were working border patrol, a guy would come through the border with a red bike every day. And every day that that person would come through with a red bike, he had a basket on the front of the bike. And inside of the basket was some food. Now, every day, this guy would come through, and the border patrol officer thought something was kind of fishy, but he never found anything. He always found baskets with sand.
Going to show you something.
Okay.
From Reddit 12 years ago.
My
The
dear
border guard
Lord.
story in r/jokes. This
Well,
is
at
the
least she didn't-
story she claimed she got from a colleague of hers.
I mean, at least she didn't get it from 50 dad jokes to read while on the pot. Why not say this is a common joke told in legal circles, but it does have something to do with this trial? Especially for easily found things like this. It makes no sense to lie or present it in an untrue way.
This happened for a few months. Well, one day, the border patrol guy was leaving that job. He was going on to a new job, and he was at a bar. And who walks into the bar? The guy with the red bike. So the border patrol guy says to him, I'm getting ready to leave my job, but I'm interested. There's something was fishy about that red bike. What were you doing with that red bike? And the guy was like, nothing, don't worry about it. Congratulations to you. The night. Proceed. The border patrol guy got some more drinks in his system. Said, you know what? Can you tell me about this red bike? Because something just doesn't seem right. Every time I would see the red bike, it would have sand in the basket. Tell me what was going on. I said, don't worry about it. Finally, it's the end of the night. Border patrol guy is really sophisticated. He said, just tell me, I'm not gonna remember what happened. You're not gonna get in trouble. Tell me what you were doing. And what the guy said was, you know how every day you were focused on the basket with the sand? I was smuggling in a new red bike every single day. So you were so focused on what was in the basket that you was missing what was right in front of you. And if you listen to what the defense counsel told you for the last about 3.5 hours that they argued, you're gonna listen what's right in front of you. So what's sand in the basket in this case? First things first, stolen jewelry. APD, somebody stole this watch. No one stole the watch. The watch is left.
We're
So
charging these men with stolen jewelry now?
No, what happened was that when they collected the jewelry from Mr. Williams' home, by the way, jewelry and watches for the total amount of $8 million.
Holy
Yeah.
fuzzballs.
And the last person who handled it before it was gathered, provably on camera, was investigator Vivarito.
Oh, wonky boobs.
Yeah, wonky boobs.
Sorry. Look, I just call them like I see them. They're pointing in opposite directions. They both have lazy eyes.
Well, it draws attention from her actual lazy eye.
Well.
And that behind that looks like two poodles wrestling in a jumpsuit.
Well, someone's going to love that. I mean, I don't know if it might be the net that she was casting out, but someone's going to love that.
Yeah, but the thing is, Vivarito held everything up to the camera. Here it is, here it is, here it is. Put it back for the evidence gathering guys. And they claim it was left behind. Because they were in such a rush, because there was a gathering of people in the bottom of the driveway. That bottom of the driveway is 50 yards away. And the SWAT team is there. You're not in a hurry. There were missing stuff. Now, draw your own conclusions. Oh, it's Biden the cat. The hair snicker.
Yes. I'm sure Jingles went crazy when you got home. He's like, have you been cheating on me with another cat? And Thor was like, I appreciate your servant, person who I don't know who pet me.
No, he just ignored. Oh, you're back. I'm hungry. That's about it.
Back in the house. But they want you to focus on this watch, because if you focus on the watch, you're going to miss the evidence in front of you.
That's called
Talking about
reasonable
no
doubt.
reports. Vivarito, she didn't write any reports. Well, what she told you is she wrote her information in the affidavits. Affidavits that get sworn before a judge. Probably.
Oh no!
Without any
Did
reports?
she swear in front of a judge? And then she destroyed her notes? Oh, thank you, Miss Hilton. That explains everything. She swore, well, she also swore before she took the stand here, where he claimed about that video with the third car that suddenly appeared that nobody has talked about, and she would still present to the judge again the falsity she presented. Yeah, I don't care if what oath she swears, because she's a lying liar who lies, and she's
Well,
trained the other
yeah.
to
And you're
lie.
typically supposed to have reports on which the judge can say, okay, where is the backing for this? Where is the
Yeah,
backing for this? At least
yeah,
that's how I assumed things worked.
yeah. Or the reports are for the defense to see. Okay, we see the affidavit. Now show us how you got there, and that Miss Vivorito, in my opinion, destroyed, because it would have showed that she was just making it up as she went along, just as the prosecution in this case. Let's see here.
Yeah.
Just checking the court stream. I'm sure I would be noticed by the chat if anything happened, but no, nothing so far.
Better than reports, because a judge has to actually read that information. But if you
And
focus
rubber
on the fact
stamp
that
it.
they're reading writing reports, you're gonna miss it right.
Yeah, but there's dumb
Mr.
judges.
Wines, we talked about length of time, we talked about that. Knowledge of co-conspirators. I think at one point in time, Mr. Shard said, Mr. Minor, who stabbed Lucia.
Oh, did you see how quickly she skipped past length of time? 3, length of
Yeah.
time. And let's go to knowledge of co-conspirators.
Yeah, again, all they're showing me are lyrics, our songs, our TikToks, our Snapchats. Show me a piece of physical evidence. I would be so irritated as a juror to have sat here for a year and not heard anything but conjecture and ridiculousness.
He doesn't know Mr. Kendrick or Mr. Stillwell? Maybe not. But he knows Khalif Adams, who's the one who helped set up Stan and Lucci. Khalif Adams knows those two. Well, knows Mr. Stillwell. Khalif Adams knows Garlington. And so some way, somehow, though, Mr. Stillwell knew on February 9th that Lucci got stabbed. Well, how does he know that?
Because people talk. You know the thing, you open your mouth and words exit, and then somebody else tells somebody else. How is that? Oh, he knew a few days later about this stabbing. Yeah, no shit, Sherlock.
Yeah, I mean, as I am part of a different culture, a culture of hillbillies, we still have, better intel than the daggone FBI. You know all the craziness that's going on around you. People talk, people gossip. It gets a little embroidered, but I could imagine that it's no different than another group of people that live together. And, most of the time, people know more before the news breaks out. Because, someone told someone told someone.
Yeah. I mean, I grew up in the Swedish version of the Appalachian Mountains. We barely had asphalt. We still got news. Well, most of the news was whose cow is this going on this road? It escaped, something of the sort, but it still got to us. And definitely, if somebody got in a fight, everybody knew, because in every tiny village, there is somebody who will gather information and tell everybody as fast as humanly possible. Or it might be, who knows? It might be a cop who told him. We don't know. But that's the thing. Always they imply, well, how did he know? Well, how about you prove how he knew? That's your job as a prosecutor, to prove a case beyond reasonable doubt.
That's what I thought, but...
How about a text message? That wasn't broadcast to the world. So this idea that just because Mr. Myrick doesn't know him specifically does not mean that they're not guilty of the crime of which they committed. They talk about witness credibility, specifically about experts and what our experts say. But if you go back to any of our experts' testimony.
So the expert, one of them got himself yeeted because he couldn't hold it in and had to completely break the rules of conduct. Then you have Detective Viborito, who lied on the stand. Then you have Detective Gaither, who must be the most incompetent cop in history, who, in my opinion, not only got fired from her position, or she got the option to leave or get fired from the APD. And then she went to a neighboring county's DA's office as an investigator and suddenly left 3 months later because, as she said on the stand, it wasn't for her. Folks, I've been doing labor law for over 30 years. Can I prove my opinion? Nope. But it sure as hell sounds like she got the option to leave or get fired, and she chose the option to leave.
Yeah.
Who else was it? Bell knob. Yeah. That knob couldn't find the back of his ass if he was looking for it actively.
Oh, good Lord. The experts, I've tuned in and tuned out, but the experts they've had, I mean, I functionally have more knowledge because I watched 8 Mile once.
Yeah. And I mean, they were all trained by Viborito.
And wasn't she trained in a 2-hour seminar?
Yeah, that's her explanation for being an expert in gangs, because once a year she took a 2-hour course in a seminar of sorts. Yeah, but that seminar was with the other gang investigators, and you trained them.
Belknap, Dennis, Gaither, Underwood. The things that they talked
I don't even
about,
remember
there were
Underwood.
examples of it. They talked about YSL as a hybrid gang. It was Bloods and Crips, and they kind of got together.
Folks, Bloods and Crips in the same gang doesn't happen. Can they be in the same record label? Yeah, if they are kept apart. But seriously, folks, Crips and Bloods have been at a sometimes not an active war, but definitely at some kind of war for decades.
Okay. But
all of a
Nicholas,
sudden under YSL, well, because it's a hybrid gang, they get along. No, they are in acceptance of the presence when they are not there. It's so immensely stupid.
it's the United Benetton of gangs.
Yeah, and that's the one thing I wish the defense put up in their case in chief. Because I know that Mr. Steele had an actual gang expert, a scholar, lined up. That's the one witness I wish they brought.
Yeah, it makes sense that what the defense said is more accurate. That, again, from the defense's premise, a lot of these young men only see rap or joining a gang as a future. And it would make sense that if you knew someone with studio time, if you knew someone that was starting a new record label, you would put aside certain things to have your own time in there, get your own time in the studio, and then you wouldn't be upset if later at another time the other side comes in. I just don't see them having, record barbecues together.
You know that Susan Martinez-Arnold's a Crip. Some of them, Mr. Williams is a Blood. You saw when he talked about sex, money, murder. You see them hanging out together. You see them committing crimes together. Mr. Kendrick and Mr. Arnold in a car with guns on their way to Trestle Tree. we can infer, go shoot it up. That's what they talked about.
No, you
They said
can't
the
infer
hybrid
something.
gang.
You can't infer a crime.
They talked about the music. And we're gonna get
Nicholas,
to the
we're not
music
seeing
in a
it.
minute.
Oh,
They talk
sorry.
about the fact that gang members use their music in order to brag, promote what they've done in the gang. And we'll see examples of that in a moment.
Oh, by the way, the Martinez Arnold she's talking about is the one guy that didn't got to the stand because Ashley Merchant was representing him.
Oh,
Yeah, and in that plea deal she negotiated in that he was only going to testify about the exact wordings in that plea deal and nothing else.
oh, wow. That's a good lawyer.
Now, yeah, but then they talked about immunity deal and stuff like that, and maybe forcing him to testify about other things through that. But as Ashley Merchant said, well, I need 5 days notice. I will not leave it to another lawyer, and it has to be before November 15th.
Hey,
If that
you
does-
need
and
that.
the judge agreed. Well, you had him on your witness list for quite some time. You even called him up from the jail or wherever he is, on 2 separate occasions, and nothing happened. You never called him on that week. So no,
No, off the desk.
I covered Miss Merchant's letter in a separate video a few weeks ago. It was amazing. Don't scratch my chair, Mr. Jingles. You have an excellent scratchy pole.
I know I need to put my cat tree up, so the cats love my desk, and one of these days my monitor is going to go flying.
Mm-hmm.
We talked about your duty earlier today, but again, just to be reminded, you're supposed to be a fair and impartial juror, honestly seeking the truth. You are not to seek doubt. So when you go in effect, you're supposed to say to yourself, what happened on January 10th?
That I don't. Why shouldn't they seek doubt if the doubt is reasonable? That is what deliberations is. Listen. First, you present your opinion, then you discuss it with the others. And if somebody has doubt, why aren't they supposed to seek it out? Because, yeah, it's stupid.
No, sir.
What is the truth about that? And is there evidence towards the truth? That is what you're here for. Seek the truth, you follow the law, and you deliberate. Now, I want to tell you this. If you go to the bank to deliberate, and one of your numbers says, I'm not deliberating, I'm going into the bathroom, I'm not doing any of this, you need to bring that to the deputy's attention so they can bring it to the court's attention. Because
Snitch on each other. That is what she's telling the jurors.
Well, yeah, but has a juror said, has this been an occasion that happened where a juror just refuses to deliberate? This is
I'm sure there are examples.
Of all the kind of things that I've heard happen, I've never heard a juror just say, like, y'all, I'm out.
Yeah. Hilton is afraid of Juror 56, who already expressed he doesn't like how the prosecution has presented their case. But Judge Whitaker asked him, well, can you be unbiased towards the evidence? And he said, yeah, I can. But he does not like the prosecution, which is a good thing.
Yeah.
Because who in their right mind would like these absolute twats?
you have a duty to deliberate, a duty to sit down, evaluate the facts, evaluate the evidence, apply it to the law. So let's talk about the evidence of the defendant's guilt. So earlier this morning, Mr. Adkins talked to you about count 57, participation in criminal street gang activity. He talked to you about count 1, conspiracy to violate the RICO Act, and counts 50 and 51. I'm not going to harp on that again, but I thought it interesting when Mr. Weinstein said, well, we haven't proved counts 50 and 51 and 57. You know, the state, they're all dressed in red. We are. Red's probably my favorite color. But you know, the one thing that's different,
That red is also your sorority color. The Sigma whatevers. Yeah. And all of a sudden, that very day, they are all dressed in the color they have claimed is the blood's color.
Yeah, it again, and with the premise of, that being correlated to any sort of overt act, I would not have done that. That, I think, would be deeply hypocritical in the eyes of the jury.
we don't do criminal gang activity. And the courts.
Are you sure, Miss Hilton? You don't do. You jailed a victim in this case just to have her on the stand. You started talking about that a witness mother, which you knew was a trigger, which caused an hour-long break because she was sobbing so hard on the stand.
Oh, what a absolute asshat.
Yeah. And so, yeah. And the Brady violations and all of that. And then go up to Fani Willis, your boss. Where's the money, Fani? Where is the money for the youth center that you got assigned to you? The money's gone. The youth center isn't built. Where's the money? You got an extra grant of $1.2 million to test SA kits. Those are still untested 3 years later. Where's the money, Fani Willis? You claim to have been broke before you got into office, Miss Willis. How can you, in just a few years' time, all of a sudden own real estate for over $4 million on a $200,000 salary? Where did you get the money from? I heard this. Oh, she's a speaker. She's highly sought after. She charges $25,000 per speech. $4 million is a lot of speeches, and she's not doing that much. Where did you get the money from, Miss Willis?
Yeah, well, also, I am flabbergasted. I know it's not my community. I know there might be different priorities, but that she got reelected with all of the things in Fulton County Jail, with all of the deferred justice, every single victim they've brought up. I mean, starting from the pink pony lady, did they ever get their cases solved? I mean, besides the ones that you said had been adjudicated. But I mean, they just brought up a parade of victims in the first part of the trial that had never had their case solved, but they tried to pin it on YSL.
Yeah. And thank you, Steve Kirkland, for your super sticker saying, try again. Yeah. Oh, Kristen says, Nick, not sure if you know, but that Euro 56 is the floor person. All right.
Okay.
That
is the floor
excellent.
person like a four-person?
Oh, yeah. I think she's meaning four-person.
Oh,
yeah.
Okay. Well, there's different, verbiage in different courts. Like some people say different things. So I figured that would be good.
Yeah. But the election, well, the DOJ released their report 3 days after the election. Yeah, not planned at all. And even though her opponent had a website and a little presence on Twitter, she still got a third of the votes with absolutely zero campaigning.
Oh, wow.
Fani Willis managed to scrape up $1 million for her campaign. $1 million for a $200,000 a year salary. I want to know where that money came from.
That is, it's so gross that a person that promises, and look, I know all politicians lie to some extent, but to actively hurt and be responsible for, someone's son, brother, husband dying because the facilities are so decrepit, to have people waiting just almost decades to get their court case through the system. You would think if you really wanted to help your community, you would, roll your sleeves up and get some of this done and not use and abuse the people that are, give you their trust, give you their vote. I know I'm a Pollyanna, but if one person dies under your watch, that's too many, in my opinion. And somebody or I don't know how many people have died in Fulton County Jail, but I know of one particular case with the bed bugs. And it's just, it really is just kind of gross to me.
Hi, Kristen. Got from KNW. Oh, that he is the foreperson. Okay. I actually didn't know that.
Well, it's good to have someone with a strong kind of personality to be the foreperson.
Oh, okay. Andrea said we made jokes about 56 being the foreperson, but it wasn't verified. Oh, okay.
Want to define what that is. See, we're not here because people wear the same colors. They can wear all the greens they want. They can wear all the snakes they want. If they all want a tattoo,
Then why did you bring it up?
Well, yeah, and why has that? Yeah, why has that been a major component? If it's frivolous, if people can do what they want, wear what they want, why is it now an overt sign of a criminal, participation in a criminal gang activity and, participation or wanting to violate the RICO Act? That is entirely different than the entire volume of your case. The judge should have objected at this point.
Yeah.
Tell them that's fine. We told it's not a crime to be a part of a gang. The crime is when you start doing criminal street gang activity, like murdering Donovan Thomas, murdering Chanel Drinks, murdering Jamari Holmes. That is what the violation is, not being a member of a gang. So you'll see, and we said it again, that on the left-hand side were the charges for Mr. Kendrick. On the right-hand side were the charges for Mr. Stillwell. In the middle is what they were both charged with. So Mr. Kendrick is charged with possession of marijuana with intent to distribute. That's from May 9, 2022, when he was found running from Mr. Williams' house.
Yeah. Never in possession of the drugs in the house. And you still charged him. You charged him with the guns in the house, which you cannot show he was near. And by the way, and this is one of the, with the plea deals, Mr. Williams took accountability for both the drugs and the guns. Now they are charging Mr. Kendrick with the exact same crime. So they are trying to convict two people of owning the same drugs and guns or having control over them.
The RICO Act seems like an extremely unfair way to charge multiple people with a crime, get multiple bites of the apple, and get as many people in prison. Now, and especially the way it's, been written in Georgia, it seems like an easy way to clear the books. And what I mean by that is if you have a bunch of unsolved murders, if you're getting, shellacked because your homicide conviction rate is, terrible, round up a couple of these gentlemen involved in a gang, say they did all of it without any evidence. I mean, this could become a blueprint to clear the books.
Yeah. Now, folks, if you ever wondered, Nick, how are we going to get content if the deliberations is drawn out? I will invite Mo. and things take care of themselves. I show her 20 seconds of Miss Hilton, and we are off for 20 minutes.
She carries her weight in such an unfortunate spot. And I try not to, okay, I always make ad hominem attacks. Never mind. I'm working on, that'll be my New Year's resolution to do more next year. I'm just kidding. Jesus, I'm trying. Anyhoozle, she carries her weight in a very unfortunate spot. You see this with a lot of very slender women. They kind of carry their weight in their belly. And it is just an odd spot because you're like, are you sure you're not knocked up? Like, I done been there 6 times. I'm pretty sure I can tell. She is just the weirdest. This is just the dumbest argument I've seen, and I studied Delphi.
Remember, the officer came and said that they both must have been out of breath and he ran from the house. And the drugs and the guns that were found inside the house, the marijuana and the guns that were found in the house. So in order
Yeah, but how do you get from he was running away from the house? Okay. In order to have possession, actual possession of drugs and guns, you need to be within arm's length. Grabbing it.
Well, yeah, it
According
does
to
seem weird.
Georgia statute.
Yeah, I don't get that he was running away and they're like, "We caught you. We found it."
She's not Miss Hilton is not pregnant. If you go back 6 months, she has the exact same belly. Unless she has an elephant pregnancy, she's not pregnant.
Hey, burrito babies are a thing. Not gonna lie. On that note, I do, speaking of burritos, have to go work on making food for. I love my children, don't get me wrong, but between doctor's appointments and getting more food, I feel like I have slightly medically fragile locusts in my house. It's just like, I just bought this. Are we out of all the Pop-Tarts? Now, Nicholas, you'll appreciate this. As feral Vikings themselves, they leave the carcasses of the snack. So I have empty boxes just littered around. So they are proud of their kills and their carcasses are their trophies.
Yeah. I tried Hot Pockets for the first time when I was in the United States. First of all, my mouth has now healed because I didn't realize it's lava inside after a few minutes in the microwave. I did the horrible mistake of actually taking a bath. Oh, it's a bit warm. Hey, no worries. Bad mistake. And
oh, yes.
So if you watch my content from when I was there, and you say, Nick sounds a bit odd. Yeah, I couldn't really close my mouth. And
I am so sorry. We should apologize. They are usually frozen on the outside and nuclear on the inside.
Yeah, I noticed. But
and you only make that mistake at least 15 times.
Yeah, and you do it because they're actually quite good.
Oh, yes. I don't know what, MSG or whatever, RFK is going to take out of the Hot Pockets, but whatever they put in there sure tastes damn delicious. Bye, you guys. Thank you so much for answering my questions, chat, and getting me up to speed and filling me in. I appreciate it so much because I have been in and out on this trial, and you guys are the key to the lore of this case. Yeah. So thank you so much. Bye.
Bye. Thank you.
You're welcome.
Folks, if this channel blows up and I'm starting to make serious money out of this, I'm going to hire Mo as my constant sidekick. So if you want Mo as my constant sidekick, start subscribing. Yeah, en masse. You know you want to. All right. Let's get on with this. We managed to play a full 10 minutes, the last hour and a half. Yep.
In order to prove this, we have to show that the defendant possessed with the intent to distribute any amount of marijuana. Marijuana includes all parts of the plant. What it does not include is the hemp products and all those other technical terms that I'm not going to try to pronounce for you tonight. We have to show that he possessed it and has possessed the marijuana or the firearm. We're going to talk about the firearm in a moment. Possession must be actual, constructive, sold, or joint. So we're going to tell you that it's not actual possession. No one caught him with the marijuana in the hand. We're going to talk about constructive possession. At the time of the alleged offense, he did not have direct physical control over the marijuana or firearm, but did not only have both the ability and the intention to exercise control over the marijuana.
He was outside of the house when you caught him. When you spotted him, he was outside of the house. No, just no. This is so immensely stupid.
We know he doesn't have sole possession or focus on joint possession. Defendants share possession of marijuana or firearms with at least one other person.
Yeah.
What evidence do we have of it? And I know Mr. Wine said we didn't have any evidence. We do. Pictures are evidence. That's direct evidence like we talked about earlier.
That's not
This is
direct
inside of
evidence.
the home of Mr. Williams.
Just being inside a home is not direct evidence, you absolute twat. That's the very definition of circumstantial evidence. He might have been in the house. You have photos of him in the house. When he was in photo from his Instagram or whatever. No drugs or guns. Penis Nana, why didn't defense object? First of all, this is the first trial I covered from Georgia. In most states, it is extremely rare to object during closing arguments. Extremely rare. It's bad form, and you might get the jury against you. Should they have objected on some occasions here? I believe they would have gotten away with it. But, folks, Max and Doug practice in this jurisdiction in Georgia on a daily basis. I have to trust their judgment on that. It is easy for me to be an armchair lawyer on this, but in this case, I have to trust their judgment.
Next to the Tupperware bowl full with the marijuana.
Okay, so where is Jack Gotti in that picture? Where's Jack Gotti in that picture? Where's the direct evidence? Where's the direct evidence? Where is Jack Gotti in that picture?
Now, ladies and gentlemen, you heard the testimony that SWAT, when they came, did not immediately make entry into the house. It was like announced, it was loud. So I submit to you that they had the opportunity to put stuff away, to hide stuff, because they didn't just come in immediately, ladies and gentlemen. So you can take that into consideration as you deliberate. Possession of a firearm during the commission of a felony. So the state must prove that the defendant had a firearm on his person or within arm's reach while committing a crime against or involving another person. For Mr. Stillwell, it's murder. For Mr. Kendrick, is the possession of marijuana with intent to distribute.
Yeah, you see the circular argument here from the prosecution? Everything we claim Mr. Kendrick was in possession, and therefore he's also during the commission of a felony. And therefore, you see the circular argument here, just spinning around? What did you see in the pictures she showed you? Was Mr. Kendrick in any of the pictures showing the drugs and the guns? No! She is presenting circumstantial evidence as if they were direct evidence. It's not. It's not even close. And thank you to Erin, and thank you to Erin again for your $5 and then your $2. Meow, meow. Let's see here. We are getting closer to 5 p.m. Nothing in court. Yep.
So how do we show this?
Yes,
On the
Mr.
left,
Higgins. He just walked
Miss
out.
Shannon Stillwell. That is Mr. Drinks inside of the vehicle. We know that Mr. Drinks was shot with
You absolute twat. His family is right there in the courtroom, and you show the picture of him. You twat. You disgusting human garbage. And everybody saw the video, Miss Hilton. Everybody saw the video. Mr. Stillwell wasn't, according to the medical examiner, science. Mr. Stillwell was, what was it, 36 seconds after he left. You saw the brake light blink off and on. We all saw it.
was raided. There were two found inside of that cabinet. There was the one that's found on this counter.
Yeah, the guns, which none were 40 caliber, which was what killed Mr. Drinks.
Now, they're also both charged with possession of a firearm by convicted felon. You have to show for Mr. Stillwell, he has 2 counts. And interestingly enough, I was listening, Mr. Sharp never talked about count 64. So, but we're going to talk about count 64. But count 52 is that he's a convicted felon and he had a firearm when he murdered Chanel Drinks. And in count 64, which is when he was apprehended, the gun that was found in the middle of the road, that we charged him with that weapon as well. And then again with Mr. Kendrick, that there were guns and drugs at Allison Drive on May 9th. And let me also say that in the indictment, possession of a firearm by convicted felon is going to be a lesser included of what is charged. What is charged is a different charge, but possession of a firearm by convicted felon is a lesser charge, and the court is going to instruct you, and you can find both of them guilty so long as you believe that both of them possess a firearm and they have been previously convicted of a felony. What do you have in evidence? You have State's Exhibit 60G and State's Exhibit 30Q. Both of those are the indictments of Mr. Stillwell, which he was charged with and convicted of a felony. So that is the felony that we're saying he should not have been in violation of, or he should not have possessed the firearm. As I just discussed, because he's a convicted felon, he should have never had a firearm when he murdered.
Erin gifted 5 memberships, and with the $2 $5 plus a $2 plus 5, she has retained the lead of honorary Viking of today. She is now up to, I believe, $72 combined in super chats and gifted memberships. Thank you so much. Thank you so much. Which also brings the total of members gifted, new members, to 62. 62 new members today. Today is a good day. Thank you all so much. Thank you so much. And Honorary Viking. Oh, I have to change back to Erin Passaretti. There. There you go. Honorary Viking of today.
For Chanel drinks.
Yeah, the gun in the middle of the road who
But
they
count
couldn't
64.
show been involved in any crimes. Maybe fleeing from cops. Okay. Yeah, but how do you prove it was actually Mr. Stilwell who threw the gun? There's no fingerprints presented. There's no DNA presented. It's for Mr. Jingles catnip. Oh! Sometimes he likes catnip. Sometimes. Not all the time. Sometimes. It's because on my driveway, there's wild catnip growing out from the gravel. So sometimes in the summer, I see him in the absolute sunshine, passed out after munching on the wild catnip. That he likes. And then I have to lift him into the shade because he will stay there in the sunshine all day if you can.
What do we have? Remember, this is on March 17th, after they fled from the Chick.
How do you show it was Stilwell's?
And remember, Trooper Campbell came in and said that he found the gun in the middle of the road. You saw the dash cam video when he kind of turned around and said, and found this gun. Then we brought in Mr. Stilwell's former girlfriend at the time, Taisha Alexander. She said that she aborted the gun. That was her gun. That gun came back to Ms. Alexander, where we were able to compare the serial numbers on both the gun that was collected and the receipt from Arrowhead Pond. And further, we played these wiretap calls for you.
Hello? Yeah.
So why didn't you charge Miss Alexander, Miss Hilton? Why didn't you charge Miss Alexander for handing a gun to a convicted felon? Because you have no proof. For all we know, she, the day before, was in the car and left it there.
I don't know. China called was like, you need to play on high speed chase to the Baba house. Yeah. Why can't he in a high speed chase if he in a rental? His rental legit. Yeah. He got my legit gun.
So the fact that she says he.
Oh, this is interesting. From Joseph Papp on Twitter. The breakdown of the deliberating jury. 7 black women, 3 black men, 1 white man, 1 white woman. Which means that all of the alternates are not black. All the black folks who were in the jury plus alternates made it to the deliberating jury. Have they been called back to the... I don't see... anything. Yes, if you just show up here and start throwing garbage, I will yeet you. I have 2 rules regarding trolling. You need to be funny or correct. If you're neither, get the fuck out of my channel. Nope, nothing about being called back. I see something from another. All right. I do have the stream right there. Let me just go check. Miss Sylvia's. If she's actually streaming. No, she is not. C11 alive. Nope. So it's just as of now, Law and Crime, 11 Alive are the only ones. And then I have Paralegal Institute. Here's also. Nothing that says they are being called back to the courtroom. Let's see if Kathy says anything. Now it is 5 p.m., so it's not impossible. Ah. All right.
Fine. When you come in the morning, as soon as all 12 of you are there in the jury room, let a deputy know, and we'll bring the evidence in. We'll secure it each night when y'all leave. So we'll bring the evidence in and y'all can start deliberating again. Don't deliberate until all 12 of you are there. And I'm just going to probably read y'all the entirety of the jury admonition. We're not every day gonna start out in court and then end the day in court. Y'all will just go to the jury room and do the same thing each day. Just wait till the 12 of you are there. Tell the deputy, they'll bring the evidence in. You can start deliberating, and just deliberate till 5 every day. As you know, if you have a question or if you want to see any of the evidence that's not back with you, write that down and let us know, and then we'll come to court. Otherwise, just treat it like a work day. At the end of the work day, you're always going to be under these same instructions, so just follow them. But I'm not necessarily going to bring y'all back here and say it every day. Just continue to be under the same instructions. So as I told y'all yesterday, to maintain the integrity of the trial, remember that you need to decide the case based on the evidence that was admitted during the trial and the law as I explained it to you. Consider only the evidence admitted in this courtroom. Don't conduct any research on your own about the case, people involved, places mentioned. Don't refer to any books or documents that may not have been admitted during the trial. Don't take or review any photographs or video of anybody involved in the case, except if it is already in evidence. Don't use dictionaries or any other kind of reference materials, including online reference materials to help you in this case. Don't use Google or any other internet search engine. Don't consult websites, blogs, podcasts, any kind of social media apps, including but not limited to a various grouping of social media: Facebook, Instagram, Twitter, X, TikTok, Twitch, YouTube, Reddit. I mean, anything like that. Don't use any of these sources of information or anything else to get information about legal terms or concepts or about the law. Don't watch, read, or listen to any accounts of this trial that might appear in the news media, whether online, in print, television, radio, or otherwise, including in any kind of a social media. In short, do not seek information about this case, including hypothetical questions from any source outside the confines of what the evidence is that is have been admitted in this trial. Remember that you are the only ones who have been qualified as fair and impartial jurors to decide this case. No other influence should affect your decision. And it is because of that that you should not and cannot discuss this case with anybody else, including your family and friends, or let anybody discuss the case or anybody involved in the case with you or around you. That includes discussing or sharing information in person, by phone, by email, text, blog, any kind of social media. If anybody does approach you about the case, or if you happen to hear somebody talking about the case, you need to let one of the deputies or court staff know that immediately. Please remember, you should continue to consider the evidence as you all deliberate with an open mind. And leave your, as you have this whole time, leave your notes or notepads with you in the jury room each night. And in the morning, I won't necessarily see y'all unless you have a question or need to see some evidence. So just begin your deliberations after you're all there. All right, y'all have a pleasant evening. Thank you. All right, we're adjourned for the day, and we will just remain in recess until we hear from the jury again, whenever that next might be. And if we don't hear from them at all tomorrow, I've told them they can leave at 3 since it's the day before Thanksgiving. We have Thursday and Friday off, so Monday will be the next time they would be deliberating. So if I don't have reason to see any of y'all tomorrow, everybody have a pleasant Thanksgiving. Thank you.
All right. That is the end of day 1 of Verdict Watch. I will return tomorrow. We will keep doing recaps and highlights the rest of Miss Hilton's streetwalker closing argument and stuff like that while we wait. So tomorrow between 9 a.m. or something of the sort, at least. No, say 9:30. 9:30. Just in case I'm late. 9:30 a.m. and 3 p.m. tomorrow. Oh. All right. Let's go through this. Thank you to True Crime Lover for becoming a new member. Thank you to Lynn Britton for your super chat. I'll get it started for story time. Yeah, and you got a story time as well. The story time will be posted as a separate video. I cut it out and it will go live at 8 p.m. Otherwise, you can always go back on the stream. Erin Passaretti, is Mr. Jingles ready for this crazy ride? He has been ready for... he has been around for a while. He is turning 9 or 10. Yeah. He is getting... Well, he's young at heart. Snivels with the popcorn. Thank you. Jessica, thank you for your dedication to covering this trial. I can't imagine it's been easy. At times, it has been excruciatingly boring. And been trying my absolute hardest, even in the most boring cell tower testimony, the most boring stuff imaginable, I try to entertain you guys. And I hope I succeeded, because there's a bunch of you who were here when I started this trial, and you are still here. So apparently I did something right. Thank you for sticking around. Kathy Hudden, just because Nick is such a cool and fun to watch. Thank you. It's so cool, Android, fun to watch. Yeah, I suspect that is a part of autocorrect. Erin Passaretti! Nick is by far the kindest YouTuber. Let's get into the 15 quick. And we got there. We got there. Thank you so much. Steve Keat gifted 5 memberships. Thank you so much. Erin Passaretti gifted 5 memberships. Thank you. Lynn Britton, we can't stop now, y'all. Thank you. Erin Passaretti, hey you. Yes, you have to hit the like button. What are you waiting for? Yeah, folks, YouTube's algo says the interactions, the chat, the thumbs up or thumbs down, that it what drives YouTube to push me to more people. So please, I know it's a bit bugging, but please do. It's free and it helps. Deja Vu gifted 5 memberships and Snivels gifted 10 more memberships. Steve Keat, New Zealand, $5. Thank you for being awesome and having a great channel. I do my best. And I mean, you guys are here. I am apparently doing something right. But most of this, I'm learning. Now, I have the advantage of already having a law degree. Yes, it's over in Sweden, but it does help. And meanwhile, we educate each other on what the F is going on in this trial. Erin Passaretti, jump up and down on the heart emoji, help boost the algo and let people know Nick and Mr. Jingles are live. Thank you. Jessica, could the jury having demonstratives be an appellate issue if either are convicted? Apparently not. It's allowed. It's allowed. Erin Passaretti again. What are your thoughts on the need for legal nurse consultants? Dave answered that question, what is it, 4 hours ago? Now, that has been posted as a separate video. Nick and Dave answers, can you go to law school after 30? So that is already posted as a separate video. Chicken Poo gifted 5 memberships. Chicken Poo gifted 5 more memberships. Then Derek Croissant became a member. Sylvia Edwards gifted 10 memberships. Thank you. Chicken Poo gifted 5 more. And 5 more. And Sylvia Edwards, 5 more. Steve Kirkland gave a super sticker. Thank you so much. Erin Passaretti, meow. Meow. And then Mr. Jingles is missing in action. He walked out. I heard him pass through the cat door. So, but he was here most of the time. And then Erin Passaretti gifted 5 memberships. And in grand total, made Erin Passaretti the honorary Viking of this stream. Congratulations. And we got to, what was it, 62? 62 new members today, which is an amazing number. Thank you so much, guys. Thank you so much. And with that, it is 11:12 p.m. here. I have work tomorrow. I need to catch some sleep so I can get to work, get the work done, represent some clients. Do I have any negotiations coming up? Yeah, probably. Sadly, Christmas is one of these times when my line of work is more difficult because we have the Christmas layoff coming up. And it's heartbreaking. It is genuinely heartbreaking every year. The amount of people who are being laid off just before Christmas. And those are the people I represent. Oh, but that is for another stream of sorts. A Christmas layoff is the end of the fiscal year for companies where some high up boss sees, oh, if I lay off a bunch of people, my bonus gets higher because I don't have so much in salary to pay out. Those are Christmas layoffs. In the end of fiscal year, let's get rid of some people and make the numbers look better. So the higher ups can get a bigger bonus. Every year. Every damn year. And I still do it. Yeah, happens every year. Different companies, different factories, but it happens every year. Christmas layoffs. Oh, yeah. Okay. Oh, folks, thank you. Thank you for allowing me to do this. Thank you for allowing me to try to interpret this absolute fuster clock of a trial for you. We are at verdict watch. We are maybe hours or days, or we don't know when they come back, but when they do, I will be here hoping for, hey, Mr. Jingles got back, hoping for an acquittal for the guys. And then when this is done, it's the other 12. Remember, this trial isn't over with the Jack Gotti and Shannon Stillwell. There are 12 more who have been rotting in jail for 2.5 years waiting for this trial to end so theirs can start. And I'm going to cover it in some way or form. Because I promised you guys last year, I'm going to cover this gavel to gavel. And I'm intending to keep that promise. All right. I will see you all back here tomorrow. Thank you again. And remember, folks, especially now when the holidays approaches, hug your family. Unless your family is crap, then screw them and give your love to the people who actually deserve it. Okay? And yeah, thank you again. See you. Ow. Stop chasing my hair. All right. See ya. Bye-bye.
Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know win, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story